Article 26 talks about the grants of everybody right to education, my lord. The next convention, my lord, para 62, my lord. The Convention on Elimination of All Forms of Discrimination Against Women. It has been ratified by the India in 1993, and Article 1 of the Convention provides with the definition that discrimination against women and girls as the different treatment from men and boys that prevent them from enjoying their human rights. It includes both direct and indirect discrimination. Article 2 provides with the state's obligation to eliminate discrimination against women and girls in all its forms by establishing laws and policies to protect women and girls from discrimination by including the principle of equality in constitutions and other national laws, my lord. And the next important convention, my lord, the International Covenant on Civil and Political Rights, ICCPR, my lord. It has been signed by the India in the year 1996 and subsequently ratified by the Parliament, my lord. The Article 18.1 says...
What is your contention? What is your contention?
My contention, my lord, these actions of the state is not in consonance with the International Treaty Convention. Just let me read the Article 18.1, my lord. The Article 18.1, my lord, the covenant protects each person's right to freedom of thought, conscience and religion. It includes the freedom either individually or in community with others, in public or private, to manifest his religion or belief in worship, observance, practice and teaching. It further provides restrictions under Article 18 plus 10, providing that freedom to manifest one's religious belief may be subject only to a limitation as are prescribed by law and are necessary to protect public safety, order, health and morals or the fundamental rights of the freedoms of others. The United Nations Human Rights Committee has stated in Article 18 is not limited to its application to traditional religions and religious beliefs with institutional characteristics. Thus, it must be interpreted broadly. This multilateral treaty in consonance with the Indian Constitution, and Article 27 and Article...
Mr. Kotwal.
Just let me conclude. Let me conclude, Milad. Article 27 and Article...
Who are you? Who are you? Will you listen to the court also? You will keep on arguing without listening to the court. Listening to the court.
Please, Milad.
First, show your bona fides. Who are you?
I'm highlighting this honorable court how India is bound by international covenants and treaties which are party to and signed and ratified by the Parliament, Milad.
Are you listening to the court or not? You will not be permitted to argue like this. You will not be permitted to argue like this without listening to the court.
Please, Milad.
What did he ask you? What did he ask you? Show your bona fides first. You are in PIL. Who are you?
I am a social activist, Milad. The petitioner is a social activist and RT activist who has assisted this honorable court in number of public interest litigations, Milad. He wanted to assist this honorable court. That's all, Milad.
No, we don't want any assistance.
In the interest of public, I am assisting this honorable court, Milad. The petitioner is a social and RT activist, Milad. Including the COVID petition, Milad. He has assisted in number of public litigation before this.
In which paragraph
he has no any personal interest. He has only a public interest.
Are you aware about the PIL rules which have been framed by this court? Are you aware?
Yes, he has filed the Yes, please, Milord. He has filed the pro forma affidavit prescribed by the Honorable Court, Milord.
Where you have made the declaration as per the rules?
Last, Milord. Page 117, Milord.
Para 117.
Start from 117, Milord.
There is no para 117 in your petition.
Yes. I Milord. That's a separate, Milord. Page 117, Milord.
What do you want to show? What do you want to show?
Pro forma affidavit, the prescribed by this honorable court, we have filed, my lord.
Where is that? It is International Covenant on Economic, Social and Cultural Rights, 117.
No, my lord.
No, that is what it is here. You mentioned that it is here.
My lord, must be after that, my lord. They're very sorry, my lord. There must be some pagination, must be some defect. My lord. Last, my lord. After all the covenants and this one, my lord, I have filed on application, my lord. 125 must be 125, my lords.
25.
125 is your wakalat.
Read wakalat.
This is separate application we have filed, not separate application filed, my lord. Subsequent to this PAL, it must be.
By such petitions, you are all wasting the time of the court in such an important matter. This much we should say. Such a serious matter. Court fee, pagination is not proper, documents are not produced, and you take time which otherwise can be utilized by your friends.
So my colleague is saying they have filed subsequently, my lord, that application it has reached the registry, my lord, already.
You are not aware. No, we'll dismiss this petition. It is not maintainable. It's not maintainable.
I'll highlight one more convention and I'll conclude my submission, my lord.
Sorry, mister, will not permit you to argue. Your petition is not maintainable.
Everything is complied, my lord. As per my instructions, my lord, everything is complied, my lord. Must be some pagination is different, my lord. That's all.
See whether there is any declaration.
Page 44.
What is this?
Pro forma affidavit.
Pro forma affidavit? No, we have to make the declaration in the petition itself.
Petition also.
There is a question of pro forma. High Court rules.
No compliance of food for trade. No compliance.
Yes.
It should be page petition. So we'll submit. We take it everywhere.
So your petition is not as per the rules. So if you want an opportunity, we can give you an opportunity
My
to.
humble submission, Milad, in the important matter, Milad, let us not get into the technicalities, Milad. Provide me 3-4 minutes, I'll conclude my submission, Milads.
Rule 14 is not technicality. I have held that it is a substantive
Will
requirement.
will you tell us that what we have to do?
My humble submission, Milad, my request, Milad. My request to provide me 2-3 minutes, Milad. Just conclude, Milad.
No, don't oblige the court. We will dismiss your petition with cost. You are testing our nerves. The public interest litigation has been filed, seeking following relief. The High Court of Karnataka Public Interest Litigation Rules 2018 have been framed, wherein under Rule 14, instructions for filing public interest litigation have been provided. A petition in the nature of public interest litigation is required to fulfill those instructions, and the public interest litigation shall be filed in accordance with these said instructions. We have perused the record. We are satisfied that the instant petition has not been filed in accordance with the High Court PIL Rules 2018. The petition as such is not maintainable. It is accordingly dismissed.
This is the first time in the last 20 PL I have filed, Milad. This is the first time my petition has been getting dismissed, Milad, under maintainability.
Because after all petitions which were filed were disposed of, new rules have been made that you have not seen.
I have complained that, Milad. In pursuance of that complaints only, I have filed a pro forma affidavit, Milad. Obliged, Milad. Much obliged, Milad. Great.
Yes, next.
1.6. Dr. Vinod D. Kulkarni, 14%.
My lords, I will not waste much of your time. Am I audible, my lords?
Yes, yes.
My humble submission to your kind, respectable lordships and your kind, respectful her leadership is that this hijab issue is creating a mass hysteria, and it is disturbing the mental health of all the individuals, particularly the poor Muslim girls who are suffering a lot. And as per preamble of the Constitution, guarding health is one of the fundamental duties of the Union of India. WHO says health is not mere absence of disease or
Same
infirmity.
problem is there in your matter also. This is also PIL. It is not as per the High Court rules.
My lords, I have supplied Rule 14, everything I have supplied, your kind lordships.
There you have given your credentials and the declaration required.
On page number 3, para 5, my credentials are there, my kind lord. Page number 3, para 5.
You have to make certain declaration as per Rule 14.
I have made all the declarations. Para number 1, para number 2, para number 3. These are as per rules only, your kind lordship.
What is your relief?
My lords, my interim relief I am claiming is that kindly pass an order today that Muslim students may be allowed to sport hijab at least on Fridays, Jummah, and during holy month of Ramzan, which is coming very soon, my lordships. My only interim relief is only that please allow at least on Fridays, the Jummah day, the most auspicious day for Muslims, and during the coming ensuing month of Ramadan. Nothing else, my lordships. It is creating mass hysteria, my lords, throughout the nation. And guarding mental health is one of the duties of the Union of India as per preamble of the Constitution.
Come to your relief, which you have prayed, page number 9.
Yes, my lord, page number 9.
Kindly read the prayer.
Whereas the petitioner most respectfully prays that appropriate writ or order or direction in the nature of mandamus or any other appropriate writ or order or direction be issued to the respondents to declare that all the students of various schools and colleges in Karnataka and in the country shall attend their institutions by sporting the stipulated uniform. And if my request to turn to page number 10, my lords. Page
You
number
want a
10.
direction that whatever uniform has been prescribed, they shall wear that uniform.
My lords, to permit female Muslim students to sport hijab, provided they wear the stipulated school uniform also. That is my prayer number B, my lords.
The contrary to each other.
My
If
lords,
prayer number A and B are contradictory.
no, my lords. Uniform they are sporting over and over, and above that, just like if I am permitted to submit to my kind lords, in Bejoy case, they stood in respect to national anthem. Here also, they are standing in respect by sporting the uniform. Only thing is they want hijab on the uniform. Akin to Bejoy case, my kind lords and my kind ladyship.
We are just trying to point out to you that prayer number A and prayer number B are contradictory to each other. In prayer number A, you seek a direction to the students to wear the uniform in the schools, prescribed uniform.
Yes,
In
my
prayer
lord.
number B, the female Muslim students who sport hijab provided they wear the stipulated school uniform also.
Yes, my lords. Hijab, we cannot say hijab is not part of uniform, my humble submission to your kind lords.
All right.
My interim relief is kindly allow at least on Fridays, my kind lordship. If I am permitted to say as lyrics from a song sung by late Lata Mangeshkar, कुछ पाकर कुछ खोना है, कुछ खोकर कुछ पाना है. We have to lose something to gain something more, my kind lordships. And 5 duties in Islam are kalma padna, namaz karna, roza rakna, zakat dena, inshallah hajj karna, my lords. And there is a Supreme Court judgment that
On Friday, they should be permitted to wear hijab.
on Fridays, my lords.
All right.
My lords.
Yes, we will consider it. What do you argue? If you want to argue, please argue.
My only kind submission is that it disturbs the mental health of the individuals, and the Quran cannot be ignored as per Chandanbal versus State of West Bengal in AIR 1986, my lords. And hijab is not against public order, health, or morality, my lords. Enough has been said that my the sporting hijab does not tantamount to if hijab is banned, it tantamounts to violation of Articles 14, 15, and 21 and 25. I will not dwell on that, my lords. Kirpans, enough has been said, my lords. Just like they allow kirpans, may I request to that this also may be allowed. And if my request, my humble lordships, to turn to page number 7 of the petition, my lords, page number 7, para 16, my kind lordships.
Yes.
May I read, my lord?
Yes. Yes.
On page number 7, para 16, that the Holy Quran, which Muslims read, recite, and practice vehemently, says that Muslim women should sport hijab and should not expose their body parts like face, neck, shoulder, etc. They are trying to conceal their parts. They are not trying.
Can you show it from Quran as to where it has been said?
My lord, offhand right now I do not have Quran with me, my lords. But if I am permitted, I can show it at some other juncture, my lords. My humble submission is to kindly accept this because it has been straightforward told by so
We
many
cannot
other
accept it like this unless you establish it. Unless you substantiate it, how can we accept it?
All right, my lord. May I go request you to go to para number 17 of the
Please
same
don't
page.
disturb me.
My lord.
Yes.
Para number 17 of page 7. He says that relief of banning Quran cannot be granted in view of Article 25 and preamble of the Constitution as depicted in Chandan Mal versus State of. Are you getting that, my lord? Page number 7, para 17.
Where is the question of banning Quran?
No, we are banning Quran, by banning hijab, it tantamounts to banning Quran also by humble submission, my kind lordship, my kind ladyship.
For you, Quran and hijab is one and the same thing.
Not for me, for the entire world, my lordship.
All right.
I'm a devout Brahmin Hindu. It is the Quran applies to the entire Muslim community throughout the world.
There is no banning of hijab as such.
No, but if the Honorable Court disallows hijab, my humble submission is it may amount to banning of Quran, may create unhappy society.
All right. Anything else?
Para number 18 of the same page, my lords, para number 18, that a religious denomination or organization enjoys complete autonomy in the matter of deciding as to what rites and ceremonies are essential according to the tenets of the religion. The whole and outside authority has no jurisdiction to interfere with their decision in such matters. Please turn to page number 8. Page number 8, my lord.
Yes.
Yeah. This is Commissioner of Police versus Jagdishwarananda, Avaduta, AIR, so and so, my lords. Hence, the honorable courts cannot interfere with the age-old and ancient custom of sporting hijab. My respectful and most humble submission to your kind lordships and your kind ladyship. My only request to your lordship is that please pass an order today to kindly allow hijab at least on Fridays and during the ensuing Ramzan with folded hands and prostrated feet. I submit your kind lordships. It will prevent a lot of unrest in the country. As I told you, my lordship. My lordship, कुछ पाकर कुछ होना है, कुछ खोकर कुछ पाना है. That's all my humble submissions, my lordships and my kind ladyship. Please pass an interim relief today that hijab will be allowed henceforth on Fridays.
All right. Thank you.
I'm highly grateful to your lordship and your kind ladyship. That's all, my lord.
All right. Thank you. Yes, next.
May make a submission, my lord.
Munir Ahmad.
3148. Please, my lord. One submission, my lord. Submission, my lord.
Which your lordship has taken. I'm joining your lordship from Delhi.
Sorry for the interference, my lord.
My pleasure that your lordship is having given time.
Yes, 2022.
Yes, your lordship. Your lordship, my lord. I'm representing girls, my lord, who are affected by this interim order. I was watching the proceedings for the last 4 days, and your lordship's queries, which were very relevant, constitutionally speaking, my lord, but to my estimation or to my perception, have not been till date right. Without prejudice to the stands, without prejudice to the argument which my learned councils made. But this government order, which is cryptic in nature, unconstitutional, illegal, we have to analyze this government order in the light of the parameters of the Constitution of India. I will apprise to your lordship. I'm a humble student of constitutional law, my lord. I will apprise to your lordship. We need not to have the judgments from Tanzania or London. We have to deal within the parameters of our own constitution, which is the complete code, which is a sacred book. And whether this order, because judicial review is with my lords, your lordship can appreciate when the constitution came into being in 1950, up to 1960, there was absolutely no problem. And the problem was cropped in 1960, when my lord Bhumi's judgment, in which my lord, that was sent to a reference under Article 143 to the Supreme Court. That was the first controversy came before the Honorable Supreme Court, how to resolve the Article 368.
Mr. Dhar, first let us understand.
Yes.
Locus.
My lord, we are 5 girls, my lord.
What locus you have to
studying in pre-university.
This is not PIL.
No, this is not PIL. This is a read petition under Article 26.
What locus you have to file
we are likely to be affected by this government order because we are the students studying in the colleges and we are putting the hijab. After this order came into existence, we are not in a position to go to the college without hijab. That's a controversy. That's a problem. Now, my lord, what are you apprising to?
Are you affected by the
yes, I have said it. Yes, I have said it in my petition. So I am affected because we are putting hijab. We are college going girls. We are receiving education. Your lordship can you appreciate, my lord?
Where you have mentioned in which school you are studying?
We have said it everywhere. We have given even in the title.
Sure.
The college is also mentioned. College is also mentioned, my lord. Yes.
You have said you are petitioner students and have been pursuing their studies.
Yes. I have given the name of colleges also, my lord. Everything I have given. But they are studying. The college is also everything. I would like to apprise on constitution because my lords have been giving some patience to everybody, but constitutional aspects have not been explained to your lordship in a way in which your lordship wanted. And the religious, I know the Arabic also, I can apprise to your lordship about whether there is a recognition from Quran or not, that will also apprise to your lordship. That is why, my lord, I am making a submission, constitution speaking. This your lordship will appreciate what I want because ultimately your lordship is, as per your judicial wisdom, your lordship has to pronounce upon the judgment. But I am assisting in that way, my lord, constitution speaking.
Oh, 1 second. 1 second, please.
Yes, please, my lord.
This is not a PIL.
No, this is not a PIL. Because we are affected. Yes.
Then in which institutions you have been studying? Which
I have studied,
institution
my lord.
prescribed?
It is pre-university classes, my lord. And we have said it, we are doing, my lord, studying, presently the college name we have also given in my petition.
Where have you
Yes.
stated that your institution prevented you? Where is that they
Yes,
have
yes,
prescribed?
it is stated, my lord. I will show to your lordship. That is not disputed, my lord.
No, the very notice itself is not issued to dispute.
The institutions have not been
It is not stated also.
Which institutions, whether it
My
has
lord,
prescribed at all?
students studying pre-university colleges, it is written and, my lord, issued the government respective number 1 to 5. We have said it, responded number 1. My lord, I have given these details.
Please read that particular paragraph which makes your cause of action coherent.
My lord, your lordship may see, my lord may see, this is Zunera. This is not my case, my lord, this is not my case, sorry. It is from Zunera. Is this, one second, my lord.
You're wasting precious time on others.
No, Huzaifa. My lord may see, your lordship may see, Huzaifa. I have said it, my lord.
Please read.
It is, my lord, we are studying the pre-university. I am submitting, I can, your lordship.
You have there are no such pleading.
My lord, I will, your lordship may see, I will file affidavit, my lord, in between, because we are studying. There's no doubt. It's an advocate of the court. My lord,
The manner in which it has been filed is not maintainable.
no, my lord, it is.
What cause of action has accrued to you? What locus you have?
My lord, locus, I will. Your lordship may say, we have said in para 2, we can give the college name also by late studying. We are regular students in Bangalore. We have said it, sir, we are pursuing the courses. I can give the name of the college also.
No. You should state which petitioner is studying in which college.
Absolutely, I will give affidavit within.
No, please, listen to us first.
Please,
Don't
please.
waste such an important matter. See
Yes,
how
yes,
you have argued, how they prepared, how you are doing this.
Your lordship.
Such an important. Please do not waste time. Please listen to us.
Please, your lordship.
Under our writ proceeding rules, we have adopted the provisions of CPC under Rule 37.
Yes.
It requires all material particulars of the case to be pleaded. You have not pleaded because you have not stated which petitioner is studying in which school has prescribed which uniform, which school has prevented you from going to the class because you wear hijab. Where are the averments?
And when
My lord, your lordship will bear with me only 1 minute. I will send a file, my lord, complete in that way, but the format was something different. I did not record. Your lordship will give me only one because I am just to apprise. I will file a supplementary affidavit in which I will highlight everything. Then I leave it to give me only one chance, my lord. I will file it today or tomorrow early in the morning.
And not here to opportunity to improve your case.
No, we will definitely do it, my lord, in supplementary. I seek because I have to approach your lord constitutionally. Your lordship will appreciate that. What is in my mind? I can assist your lordship to that. And then ultimately your lordship may decide the case. Because there are certain important things which have not been brought to your lordship's notice as senior counsel who knows a little bit constitution and the religious also. I want to assist your lordship on that. Meanwhile, I can file the supplementary affidavit in which I will highlight this thing. It's an advocate of record who has committed mistake.
We will dismiss the petition with liberty to file afresh. Giving all necessary particulars.
Your lordship, I will do it today, and your lordship will. That's correct. Your lordship will say so. Absolutely no problem. Or if your lordship could consider, because since now it has come on board for last 4 days, I was waiting. I can file supplementary in which I can place on. That's your lordship's choice. Your project. Your lordship project.
Heard, Mr. Dhar, senior advocate. The petition. Petition has been filed seeking following relief. After going through the record, we find that necessary particulars about the cause of action accrued to the petitioner is not being given. At this stage, Mr. A.M. Dhar, senior advocate, appearing for the petitioner, makes a statement in the bar that he may be permitted to withdraw this writ petition with liberty to file afresh. For the stop with regard to petition is accordingly dismissed as withdrawn with aforesaid liberty. To file the statement of objection.
Yes, ready, I'll start tomorrow.
Not because this is a special bench. We have individually we have many matters. We have pressure also.
I understand.
All cases ರೀತಿ ಮಾಡಿ ಚಲೋ matters how they have argued that should not be damaged by these people.
Therefore,
What kind of such an important matter? Special bench is constituted within 1 day by the Honorable Chief Justice, and everybody wanted at earliest point of time. So beautifully they have presented the case. Now they intervene and they want to damage the merits of the petitioner's case or what? We do not understand. Please start. If there is difficulty, we'll give you.
tomorrow. Yes, I'll start and find
Who are the other counsels appearing for respondents?
My lords, in the writ petition, my lords 2146, I, my lords, appear for the party respondents 15 and 16, who are, my lords, the College Management Development Committee and the local MLA, the allegations against our college.
I start from the state. I think not it would be appropriate for me. And I don't know the others would argue. First thing, not start. Give me that intelligence.
We'll hear the other counsel for respondent.
The state, there's something fundamental. I have to start. Some actual aspect of I expect it to tomorrow I start and what's make a meeting.
The learned AG was making that request. May I make a request that if time permitting today was I may get 10 minutes. That's all my request is. And any 10 minutes by the clock of the lordship's time.
We'll permit you, then we should permit everyone, all the intervention applications.
Because the lordship told me to 10 minutes, because there's nobody else. Because I quite see that. May I make a suggestion for the lordship's consideration? Now the lordship has 1 hour of normal court time. Lordship is 10 to 6 to then. Whoever the interveners, today lordship will hear the interveners. And then let's close it. The respondents will begin tomorrow.
Next day you'll say to that day you had permitted, today you are not permitting.
Plus this.
All this discrimination, we cannot do that.
But lordship may take it from tomorrow. Okay, I'll start. Sorry, what's the ready some small discoveries tomorrow. I'm sorry for the
Statement of objection be placed.
It has been filed statement of objection.
Let start with that.
I thought there's some I have to list of sorry, list of dates.
If we are going to modify the government order, then it's all right.
No,
Give me time.
No, certainly not.
No problem.
They have argued it less. Kindly give me that indulgence tomorrow. They have argued for 4-5 days. All that I'm requesting is 2:30. First thing in the
Let Mr. Boyer argue.
I cannot have a buy. We had to prepare for in a manner which I thought would be appropriate for me to start on behalf of the state. I want to play something fundamentally simple here. Thereafter, of course, the can start.
My lords, I may agree with the AG, my lords. I don't want to, my lords, come in between the state and because for whatever it is, my lords, the state must defend their action. Thereafter, my lords, I have something to say, my lords, in terms of what the college has done and how, my lords, we are in consonance with the law. But I think, my lords, it may be prudent for me to go after the learned AG does.
All right. Mr. Naganand.
So appear one of the respondents
in one petition, I am appearing for one of the lecturers in a college against whom some allegations are made. I will also seek leave to make my submissions after the AG finishes, because the main constitutional issue that has been raised, my lord, has to be answered by the state. I can only supplement. I will not take more than 15-20 minutes. That's all I will.
All right, then we will rise. Pick up.
Lord, I have a small request to make, Lord, if your lordship would consider.
Yes.
Lord, although our application is for seeking to intervene in the petition, and more particularly writ petition number 2347 of 2022, Lord, but our intervention application, Lord, is not seeking to address to the issues which possibly the respondents possibly would be, Lord, seeking to argue. Lord, give me, Lord, half an hour today, if possible. Lord, I will demonstrate to Lordship, Lord, the research, the kind of research we have done. We will demonstrate to Lordship, Lord, that this is not for the first time that Lord, the courts of this country have been called upon to address to the issue of hijab and growing of beard. And Lord, all these issues have been addressed. Lord, as a matter of fact, our Bombay High Court, Lord, the bench headed by Justice R.M. Lodha, Lord, sitting with Justice D.B. Bhosle, Lord, and so also, Lord, Kerala High Court have gone into the issue, this very issue of hijab. And Lord, courts have held that this is not an integral part of religious practice. Lord, every time, so now the question, Lord, which Lord, I'm seeking to raise is this, that every high court in our country are supposed to address to this issue, and your lordships, Lord, invaluable time is supposed to be encroached upon by litigants after some interval or the other. That's the issue, Lord. And I'm saying, Lord, we are also saying, Lord, this is the first limb of our argument. Will satisfy. Give me, Lord, half an hour. I have circulated the compilation judgment, and there is an answer to all the issues which have been, Lord, raked up. Lord, I can also go on for arguing for days together, hours together, but I'm not. I'm only saying that permit me, because Lord, your lordships have been hearing only one side of.
All right, Mr. Subhash Jha.
Yes, Lord.
We have said that we will first hear the petitioners' counsels, then we will hear the respondents. Then thereafter we will decide as to whether we require any intervention by anyone or not. Then at that stage we will decide that whom to be permitted to argue as an intervener. Right now we are not permitting anyone to intervene.
I quite see. But Lord, you
also understand it is for the court to decide as to whether intervention is required or not, and whether anyone should be permitted to argue as an intervener or not.
Certainly, yes.
Yes.
Certainly.
So right now we are not permitting. We have said this thing to everyone that right now we don't want any intervention. We will first hear the petitioners and the respondents, and thereafter we will decide about it.
Only one small, Lord, request. Lord, if your lordship could consider this. Now, Lord, in view of authoritative decisions, my Lord, at least of 3 courts, or rather, even the Supreme Court on the issue, similar issue, whether growing of beard is an integral part or otherwise.
If you want, extend your help to your friends who are on the respondent side.
Very well. Very well.
If you want to give anything.
I may make a submission, my lord. Lords, may I make a submission, my lord.
Wherein the act itself is not applicable in the realignment of 2030. It represents all the minority schools and also the Malaysian CBC. The number is there. Just 2 judgments.
You have also moved some intervention application.
Writ petition.
Writ petition. Which one?
No, which is the petition now?
Here before us, whether your petition is there.
No, it's filed. It is not listed.
You have tomorrow. It will be coming tomorrow.
No, it's filed, but it is not listed unless I do the matter. Because matter pertains to the very notification is that it's very that it cannot be made applicable to the minority, including the right of PM judgment and other pre-judgment which I stated.
What do you want? What do you want?
Especially for listing the working matter.
Some fresh matter, already pending matter.
We have given a representation, and also we have given a complaint to the government also.
Fresh matter, where it is? It is in the registry.
Number is not given. FR number is given. It is filed today. By minority commission? No. Who is the petitioner?
Karnataka State Minority Education Management Federation. We represent both ICC, CBS schools, where all minority students. Wherein in fact we also present Ramati Education. The representation of Muslim minority was allowed. Both here, so that's why.
You filed it today.
Yes, sir. Yes, Article 140, Section 141 of the Act.
Alright, we don't want to go on that. Thing is that you filed it today. Please ensure that does not have any objection.
Yes, sir.
Please ensure that we'll call it tomorrow. We'll call it tomorrow.
May I make a submission, my lord? In writ petition number 3148, my lord, your lordship had dismissed my petition on the basis of the maintainability, my lord. So as per my instruction, I have completed the rule 14.2, my lord. So is there any office objections, my lord? I'll complete today itself, my lord. It may kindly be heard tomorrow, my lord.
May I pass the order, Mr.
It's my only humble submission, my lord. If at all, if you are not complete, my lord, office would have raised this office objection, my lord.
We can't help you.
Permit me to complain, if any, my lord. Kindly hear me tomorrow, my lord. That's my humble submission, my lords.
We gave you opportunity. We asked you if you want, you may file affidavit. As per the rules, you said nothing. You wanted to argue, you argued, we have passed the order. That is all.
Right.
Yes.
Maybe on the maintainability is dismissed, my lord. If it is on the merit, there is no issues, my lord. So even after complaint, the rule 14 subclass 2,
pass the order. Thank you very much.
dismissed for maintainability, my lord. It's not fair. I concede. Obliged.
Yes.
Violation of immunity and is no violation of the so kindly any mediation can be referred some group of ladies so that we can mediate because whatever may be the judgment after that also everybody will be starting more.
Mediation can be done between the parties who agree for that.
So we can try to take that.
You are appearing for whom?
After any judgment.
Who are you? In which case you are appearing?
My lordship, just now application, the pleading application I have filed. And that required, but my lordship can allow any petitioners if they, or else I will ask the petitioners.
No constitutional issues are involved. We have to answer those issues. How can a mediation?
Argument on other grounds, okay, but this is the violation. Every day we are seeing that girls.
No, we do not find this.
Mediation is really it's a good mind.
Mediation cannot be done in this manner and not in such matters.
Mediation with the director, we can go and we can, or else we see they can be called to girls and group of girls. I am very much confident that we can convince even the modification also because any order that will create a violation.
He is trying to understand the basic principle of mediation is that mediation can be done between the consenting parties.
I know.
Those who agree for mediation.
That I will take the first before that I am taking permission my lordship. Then I move to the other petitions and I will.
You first move to the other petitioners. You move to the other petitioners and to the respondents and if all of them agree, then we will consider your request.
My lordship.
Yes. First maintain your petition. Only then anything can be done. Your petition at present is not maintainable. There are so many defects in that. Tomorrow 2:30.
Number 1. May not be yet.
Appear for the petitioner in this case, my lords.
Yes.
My lords, this matter, my lords, it is pertaining to a license which is not being granted by the third respondent, my lords.
Number 1.
Appear for the petitioner in this case, my lord.
Yes.
My lords, this matter, my lords, it is pertaining to a license which is not being granted by the third respondent.
Time delay. That audio I was talking. Audio was ನಮಗೆ ಡೈರೆಕ್ಟ್ ಜೂಮ್ ಕೊಟ್ಟಿದ್ರೆ ಡೈರೆಕ್ಟ್ ಜೂಮ್ ಸರ್ ಡೈರೆಕ್ಟ್ ಜೂಮ್.
My lords.
Yes.
Lords, petitioner is seeking a mandamus against the third respondent, my lords, for granting of license. This matter is, my lords, covered by the judgment of this honorable court, my lords.
Yes.
May I submit the facts, my lords?
Where is the judgment? Have you annexed?
Annexure E, my lords. Page 31.
You will also give the page number.
Page number 31, my lords. Annexure E, page number 31, my lords.
Yes, what has been held?
My lords, it has been held that, my lords, once the certificate of compliance is and consent for operation is given by the licensing, given by the authority, my lords, licensing authority shall grant crusher license, my lords. Relevant portion is at ink page 38, my lords.
Yes.
Last fourth line, my lords. It starts from last fourth line.
Yes.
Once an applicant secures and furnishes a consent of operation as stated above, the licensing authority is bound to grant license to the applicant in the prescribed form as mandated under subsection 2 of 6A of the said Act 2011, my lords. Now, my lords, petitioner has obtained the certificate of compliance, my lords, and pursuant to that, my lords, he has obtained the clearance from pollution board, and the forest deputy conservator of forest has also issued his permission, my lords.
Yes, what do you say? Who appears? Correspondent?
Government, my lords.
Yes, Mr. Mahendra.
I appear for response of conversion certificate.
Yes.
If he produces conversion certificate,
my lords,
will place it before the license.
My lords, conversion certificate, my lords, petitioners applied for the conversion, my lords. It is in
converting the land from agriculture state.
You are not clear. Your voice is not clear, Mr. Mahendra. It is breaking. Some signal problem.
Mahendra, there's some connectivity problem at your end.
It's not there.
Yes, this is Mahendra.
Yes.
Then it is.
But your lords may kindly pass on, Lord, I'll inform him.
No,
Madam, the AG's office will need to get the data.
Disconnected again, I have connected. Am I audible?
Yes.
Am audible?
Yes, now you are audible.
Am I audible?
Yes, you are audible. Please
It was
speak.
disconnected. Lord, my submission is, the moment he produces, Lord, the conversion certificate, we will place it before the licensing authority, and this license will be considered by the licensing authority. This application will be considered by the licensing authority.
All right. Yes. What do you say?
My lords, the petitioner has applied for conversion on July 11th, my lords. My lords, I would like, I would request your lordship to kindly look into Karnataka Land Revenue Act, my lords, section 95 clause 9, my lords, where it says, my lords, if the application is not being disposed of within 60 days, my lords, it is considered to be a deemed conversion, my lords. Section 95(9) of Karnataka Land Revenue Act, my lords.
Can they act upon treating it to be a deemed conversion?
95(9), Lord.
When the act requires the conversion certificate, then you have to produce it.
My lords, when
or get a direction from the court first that it is a deemed conversion. Only then they can act upon.
My lords, the
automatically they cannot treat it to be a deemed conversion.
My lords, the DC has not accorded permission till now, my lords. The application is still pending.
Then your grievance is twofold. First grievance is that the conversion certificate has not been granted to you. For that you have not made any prayer.
My lords, I would request my lords to kindly look into section 95(9), my lords. Once the application is filed, my lords, it shall be considered as deemed conversion, my lords.
We cannot direct them to treat it as a deemed conversion and act upon that.
So when they have to ask for seek for a prayer to that effect.
My lords?
You have to seek for a prayer to that effect.
First, unless the conversion is granted, this license cannot be granted to you.
If my lords permit, my lords, I would read the section, my lords.
Do you want us to hold that without conversion certificate, the license cannot be granted?
No, my lords.
We will hold it. There is no problem to that.
No, my lords. No, my lords.
Then please understand, you will have to seek for prayer to that effect.
My lords,
application.
My lords, that is true, my lords.
What they are pleading, we will have to.
One more petition.
Let him file. Let him first get the conversion certificate. Only then you can ask for the license.
My lords, the DC has not accorded this permission, my lords. My lords, the Land Revenue Act is very clear about that, my lords. Once the application is filed, my lords.
All right, then we will decide about it. All right, we will decide this issue.
Please, my lords, I would request your lords to, my lords, kindly look into Land Revenue Act.
You insist for that, then we will have to decide it.
My lords, I'm not insisting, my lords. I'm just requesting.
Give section 6. We'll decide it.
Section 95 clause 9, my lords.
We are not deciding that issue. That issue is not before us. That issue is not before us.
My lords, in that case, my lords, I would request for a week's accommodation, my lords. I will look into what is the current status of the application filed by the petitioner.
No, let this be first decided.
My lords.
Third, writ petition has been filed seeking following relief. The counsel for the petitioner submits that in view of the judgment of this court passed in the case of ICRA granite crusher versus State of Karnataka, WP number such and such, date of judgment 14th of July 2020, the licensing authority is bound to grant the license to the applicant in the prescribed form as mandated under subsection 2 of section 6A of the Karnataka regulation of Stone Crusher Act 2011. The submission is that the licensing authority cannot hold the license of the petitioner and is bound to grant the license in the prescribed form in view of subsection 2 of section 6A of the Act. The counsel for petitioner submits that the consent for conversion of land was applied in the year 2018.
15, my lords.
15.
Please.
And in view of section 95 of Karnataka, what is that act?
95 clause 9, my lords. Karnataka Land Revenue Act.
Land Revenue Act under section 95
clause 9.
Clause 9. In case the conversion certificate is not granted within 90 days. What is the period prescribed?
No, my lords. Once the application is filed, my lords, for permission for diversion of such land, it shall be deemed to have granted subject to obtaining license or working permission at the said enactments.
Where are you reading?
95 clause 9, my lords.
What you have written?
Under section 95(9), in case the conversion certificate is granted within
No, cut that. Whenever any occupant of land,
please, my lords,
assessed or held for purpose of agriculture wishes to divert such land or any part thereof for the purpose of quarrying of mining mineral, whether specified or non-specified in accordance with the rules governing quarrying of minor mineral or stone crushing activities under Karnataka Regulation of Stone Crusher Act 2011 shall make an application along with fine applicable to the Deputy Commissioner for diversion of such land. On such application, the permission for diversion of such land shall be deemed to have been granted subject to obtaining lease or license on working permission under the said enactment. It is submitted that where is the period prescribed? You said 90 days.
My lords, the period for disposing any application for conversion of land, my lords, it is 60 days or 90 days, my lords.
It is submitted.
The application should be disposed of within such and such date.
Of 90, normal conversion is a time. Here, once it is made, it is deemed to be granted.
It is submitted that the time period prescribed for conversion of land is either 60 days or 90 days under the Karnataka Land Revenue Act 1964, and as such, after the period of 90 days, the conversion of land should have been allowed and it shall be deemed converted for the purpose of stone crushing.
Please, my lords.
It is further submitted that in view of the aforesaid fact, the licensing authority was required to treat the consent for operation certificate and thereafter issue the license. Mr. Mahendra, Leonard AGA, appearing for respondent on the other hand submits that in section 6A is very clear. Section 6A of the Karnataka Regulation of Stone Crushers Act 2011. Above you write it, the act. is very clear. It provides that the licensing authority on production of consent for operation certificate issued by Karnataka State Pollution Control Board shall grant license to the applicant in such form as may be prescribed. The licensee shall adhere to the conditions as mentioned in the Act. Now, this is with respect to the consent for operation issued by the Karnataka State Pollution Control Board, where it says about the conversion certificate.
But under 6.2 it is not stated.
Under 6, not 6.2 states.
Under 6.2 it is.
Then how you say that as soon as the certificate is produced?
May I make a submit?
Please, my lords.
Lord, may I make a submission?
Yes.
Lord, under section 3, please, Lord. Section 3, stone crushers to obtain license. No person shall carry on business of stone crushing in the state except under and in accordance with the terms and conditions of license issued under this Act. Lord, it is a business. Stone crushing is a business. That business cannot be conducted on an agricultural land.
Where you have read what you have read? First, section 3. You have read something from the book. Which section you have read? Very difficult. There is some signal problem at your end.
Lord, 3. We have Karnataka regulation of stone crushing. Lord, section 3, please. Section 3.
Yes, no such activity can be carried out without license.
Yes, Lord. This is a business, Lord. This is basically business. Stone crushing is a business that cannot be carried on in agricultural land.
Physically and get us.
Yes, my submission.
This way we cannot carry on. You are not very clear, and we do not know as to how you said that the consent conversion is necessary.
Consent for Lord, my submission is consent for operation is different, Lord. The status of the land on which the stone crushing activity may be permitted is different. Stone crushing
now you
activity
said that this conversion certificate is necessary as soon as he will produce, we will consider granting of license. Now, from where you have read this?
Lord, my submission is stone crushing activity under section 3, please, Lord. Am I audible, Lord?
I am you cannot read into the Act more than what is there. Once under 95(9) an application is made and conversion fine is paid, it is deemed to have been converted on that date. Just because your officer does not issue a conversion certificate, you cannot now say that we won't consider this application. 6A2 does not require that.
Lord,
if the Act provides that certificate is necessary, then all right, we can say that unless the certificate is produced, conversion certificate is produced, that cannot be done, license cannot be granted. But show us from the Act.
Lord, may I draw your Lordship's kind attention to section 3, please, Lord.
You cannot benefit, you cannot take benefit of inaction on your part itself. If that is so, we were given the impression that this certificate is necessary for conceding the license.
No.
As per the Act. But the provision does not say. Provision says with respect to CFO from Pollution Control Board.
My Lord, yes, Lord. Conditions, Lord. May I draw your Lordship's kind attention to section 3, please, Lord. Section 3 of the stone crushing.
Section 3, we have seen it.
You have read it out twice, Mr. Mahendra.
Section 3 does not say about the certificate. It only says that no person shall carry on activities without license.
Without license, Lord, this is my submission is stone crushing is a business.
Maybe whatever
Using machinery
require conversion, Mr. Mahendra.
That is exactly for the reason I'm making this submission, Lord. Business cannot be carried out on an agriculture land, for which they have to seek conversion.
You are not granting. It is a deemed conversion.
True, Mala, deemed conversion, we do not know whether he has applied for deemed conversion, on what date he has applied, whether he has paid fine for deemed conversion, we do not know. Unless it is produced, Lord.
And now you are coming down to an application being produced.
Correct.
Mr. Rohit, will produce the application for conversion before the authorities.
My lords, I shall produce the application, my lords.
Now you produced it along with your application for license.
No,
application for license,
exactly
my lords.
for the reason, I made a
My lords, application for license has been pending since 7 years, my lords.
So you filed your application for conversion in 2015. And you gave the conversion file. Now you placed it before the authorities. Otherwise, how will they get to know?
My lords, in that case, my lords, I will place before a lordship the application and all the relevant documents, my lords. Seek for an adjournment, my lords. I will produce the documents, my lords. If they are insisting for that, my lords, we will produce the application filed before the deputy commissioner, my lords.
It is better that you withdraw this petition, file proper petition.
My lords, the question here is, my lords, the act does not say that conversion order is required, my lords. That is the reason we have filed this petition, my lords. If in case,
Don't go by the observations of the court.
No, my lords, no, my lords. Sorry, my lords.
Don't go by.
Definitely,
Yeah, very dicey.
Please, my lords.
Have you made
the application?
What we
consider
find
the application of the
from your
petitioner.
pleadings also, you have not said anything with respect to deemed conversion. And
please, my lords.
Unless your land is meant for the stone crushing activities, how can you be permitted to carry out the activities on an agricultural land? It cannot be permitted. First, you will have to satisfy the authorities that you can get these activities done in your field.
Please,
for that, you will have to satisfy them that the relevant conversion is there in your favor. But there is no pleading.
My lords, may I request, my lords, I seek for an adjournment, my lords, posted on Thursday or Friday.
It will not help you. You cannot change the entire nature of the case by amendment.
Please,
therefore, it is better for you to withdraw this, file a proper petition. Saying all this so that we may also take cognizance of that, we may direct the authorities.
Please, my lords. Please, my lords.
Proper prayers.
Please, my lords. Please. Lords, seek liberty, my lords, to file a proper petition.
Third, remove all the cut. Learn counsel for the petitioner. After arguing the matter at some length, makes a statement at the bar, write his name also, that inadvertently by mistake, he has not made necessary pleadings and proper prayer in the writ petition, and as such, he may be permitted to withdraw the writ petition with liberty to file afresh. The writ petition is accordingly dismissed as withdrawn with aforesaid liberty.
My lords, I appear for the petitioner in this matter. My lords, on the last date, my lords had directed the respondents to file an affidavit. My lords, an affidavit has been filed. This is an affidavit dated 26th November 2021. Now, my lords, this is an issue wherein there has been encroachment on land which is demarcated as a conservation reserve under the Wildlife Protection Act. That means it is an act which there can be no encroachments and has to be preserved. Now, my lords, kindly, if may I request if my lords could see this affidavit, this compliance affidavit that they have filed, my lords. My lords, this is dated 26/11/21. If my lords have this affidavit, I have been served, my lords, because in this affidavit they admit that there is large scale encroachment in this in the land, and still no steps are taken to remove the encroachments. Could do my lords have this affidavit, my lords, 26/11?
That it's a compliance affidavit, my lord,
Yes,
along with annexures R1 to R4.
It's a compliance affidavit dated
filed on 26/11.
26/11. If my lords have it in their files, my lords.
Yes.
Yes. Could I just refer to this affidavit, para 6 onwards? Para 6 of this compliance affidavit that they have filed, para 6. In fact, in para 6, if I may read out, in these meetings, some meetings were held based on the directions of my lords. Timely directions have been issued and coordinations among the officers concerned were solicited in order to complete the survey of lands, analyze the encroachments, to file complaints before the special court, to secure ownership by evicting the encroachments, and other measures to develop the lands. Similarly, para 7-8, they continue to say that meetings noted that there is encroachment of lands. And in fact, one of the meeting annexures, which is at page 19, kindly if page 19 of the same affidavit, if I may kindly request my lords to refer. This is minutes of the meeting held on 11/8/21. Page 19, my lords, of the same affidavit. And this is minutes of meeting held on 11/8/2021. And if my lords can see, point 1, Chikmagalur, as Deputy Commissioner was on another meeting, additional DC told in the meeting that totally 4,266.02 acres of land has been encroached in this district. This land is to be evicted and there is no eviction since last year. My lords, the eviction we are seeking is that this is conservation reserve as directed, as issued under a notification of the
All right. What has been done in the compliance?
Nothing has been done. All they say in this compliance affidavit is that they have
all right.
meetings.
All right. Who appears for the respondent?
That I appear for the state, lord.
Yes.
They have to report on eviction of encroachment. What are they doing about that?
All right. We are calling upon them to explain.
Sorry.
Yes.
Lord, your lordships may kindly appreciate this, lord. This was a special scheme. Under a special scheme, lord, the central government, in order to, lord, encourage...
We do not want to know anything. We want to know what compliance has been done, and kindly show it from your compliance affidavit, what compliance you have carried out.
Lord, 2 minutes, lord.
Yes.
Lord, without knowing the, lord, the intention of the government in earmarking this land, lord, for Amrit Mahal Kaval lord, project, in order to, lord, encourage cattle breeding. Lord, it was a union government's scheme, lord, and this land has been identified under the scheme. And lord, Kavalgars were, lord, appointed by the state government to oversee and, lord, cultivate these lands for this very specified purpose. Admittedly, lord, there have been certain encroachments which we have, lord, identified and then given them notices. But pursuant to the notice given, lord, and a notification was also issued by the state government asking them to, lord, retain only 2 acres of land for cultivation under the scheme and to return the entire the balance land. Lord, the writ petition was filed and interim order was obtained, lord, by those alleged encroachers. But that writ petition we got it disposed of, lord. The learned single judge has directed that the circular issued by the state government should be obeyed by the petitioners. Undertaking that, lord, recording the undertaking of the petitioners, lord, that writ petition has been disposed of. And lord, now we are in the process of taking the possession back from those encroachers. This is one step, lord.
How much possession of the land you have taken till now?
Lord, your lordships may kindly see that, Lord, in paragraphs 12, 13, 14, I have stated so, Lord, in this affidavit.
Madam, the order that you have to comply is dated 5/3/2020.
Lord,
There are 2 years from that date.
Lord, encroachments have been there, Lord, for past several
So
decades.
what is the action when you are signing a compliance?
We have already initiated.
Where are the details? There are no details in the compliance affidavit.
Lord, the several
Which paragraph you have said that so much of land possession has been taken over?
Para 12, 13 and 14. Lord.
No, it is not there.
Not.
It is not.
In para 12, they say
Para 12 says
1200.
nearly 12 acres of land encroached by public in
17
covers and encroachment in 50 acres of land have been evicted in Karnataka.
Kannakattai Amrut Mahal Kaval. And Lord, para 13.
Out of this 1212, you have removed the encroachment in 50 acres.
The 12,1200 acres in 17 kavals, 17 pieces of lands, Lord, across various districts. Lord, para 13 also may be read together, Lord. Lord, para 13 in Davanagere district, Lord, the last 3 lines. In Chikmagaluru district, there are no encroachments at all.
Here I would like to just pause. On one hand, they say Chikmagalur, there are no encroachments. And I pointed out to my lords at page 19, in the meeting they say in Chikmagalur, there are 4,266 acres of encroachments, my lords. It is in their meeting at page 19 that they have produced of the same affidavit, page 19, which I read out, my lords, minutes of the meeting. That in Chikmagalur, at page 19, that the assistant additional deputy commissioner.
In paragraph 13, what they want to say is that only with respect to 2 covers,
they have evicted. Maybe.
Devanuru and Basuru of Chikmagalur, there is no encroachment.
That is, my submission is completely false because the whole petition is filed for this, my lords.
You can say that you are not supposed to. Whether the principal secretary has filed this affidavit?
Lord,
Forest.
The deputy director, Lord, of
Why?
Mahal Kaval.
5/3/2020 order says for considering to be filed by principal secretary of forest department.
Lord, that, Lord, I have prayed for recalling of that in a paragraph, Lord, because principal secretary forest has nothing to do with this project, Lord. It comes under animal husbandry. In fact,
whether the order has been modified?
But that has not been done, Lord. I have prayed for that.
You may have prayed anything.
Lord.
Order is very much intact.
Lord, he is not the authorized person, Lord. These lands won't come under the forest department, Lord. So he is not the authorized person. In fact, Lord, in the statement of objection filed,
order is very much there. How can you say that this order need not to be complied?
Lord, I have prayed.
File the affidavit of principal secretary forest.
But since he is not authorized, Lord, he is not sworn to this.
Honorable Court had personally directed him to look into it. In fact, 5/3 said
but he is not the person authorized, Lord.
Well, then my friend should seek some modification. Then my friend should.
I prayed for so, Lord.
Where is that? Is there any application?
No application, no memo, nothing is filed, my lords. They were only taking time thereafter to file this affidavit. And now the affidavit was filed after 1 year, 1.5 years, after 5/3/2020.
We are not.
Until then,
order was passed after informing you that contempt proceedings would be initiated. Despite that, this is the manner in which the affidavits are filed.
Lord, since the complaints affidavit is filed, Lord,
they don't discuss any complaints.
Like this is the complaints, my lord. Task force committee has been doing some works,
All right.
my lord. They have moved the special court.
All right, we are initiating contempt proceedings against Principal Secretary and your this Deputy Director. All right.
Lord, your lordship may kindly appreciate this, my lord. There is complaints affidavit filed by the
We held
state.
him responsible for non-compliance of the court's order.
That Forest, Principal Secretary Forest is not the authorized person. It's under the animal husbandry.
We are not
But
concerned about all
in the
this.
petition,
We
Lord,
will go by the court's order. Whatever orders are there, they need to be complied, and we do not find the compliance.
that this is a compliance, Lord, to show because the
All
encroachments
right,
are
we'll
being
note,
raised.
we'll note down that you say that this is the compliance. Take down. The court wide order dated 5/3/2020. After recording in detail regarding the alleged encroachment of the forest land. It is a reserve.
Forest and
This is conservation reserve. It's forest, my lords. It's conservation reserve. In fact, it's more.
It's
Forest
Amrut
land.
Mahal Kaval, Lord. It's not forest.
Had directed the Principal Secretary Forest Department to look into the matter. He was also required to ascertain as to whether a special task force constituted under the orders dated 2nd of December 2018 is functioning. The Principal Secretary Forest Department was directed to file the affidavit, and time was granted till 31st of March 2020. It is to be noted that thereafter, the respondent kept on taking time to file the compliance affidavit. Today, when the case is taken up, the then AGA submits that compliance affidavit dated 26th of November 2021 has been filed. First, the perusal of the compliance affidavit indicates that the same has been deposed by one Dr. Hanumant Naik Karbari, Deputy Director, Amrut Mahal Cattle Breeding Center, Department of Animal Husbandry and Veterinary Sciences, Chikmagalur. There is no compliance affidavit filed by the Principal Secretary Forest Department. From the perusal of the compliance affidavit dated 26th, filed on 26th of November 2021, we are not at all satisfied with respect to the steps taken for removal of the alleged encroachments. Here it is to be noted that in the meeting dated 11/8/2021, which was held under the chairmanship of Secretary Animal Husbandry and Fisheries, it was noted that in Chikmagalur district, 4,266.02 acre land has been encroached in the district. Whereas in the compliance affidavit filed on 26/11/2021, in paragraph 13, an effort has been made to give the impression to the court that no encroachment is there in district Chikmagalur. It is stated that in Devanuru Kaval and Basoru Kaval of Chikmagalur district, there are no encroachments. It does not disclose as to what encroachment has been found and what steps are being taken to remove the said encroachment in district Chikmagaluru. Full stop. We are also surprised to see that in the entire compliance affidavit, nothing has been said about the encroachments having been removed, and only it talks about the meeting held for the eviction of encroachments from Amrut Mahal Kaval lands.
Lord, may I seek your Lordship's indulgence here, Lord? Target of 25%, the removal of encroachments has been given per month, Lord. Lordship, may kindly see paragraph 8. Lord, earlier, Lord, there was miscommunication between the departments, Lord. Now a new principal secretary has come for animal has been taken this up as a Lord. Taken this as a Lord main target.
Try to submit that in paragraph 8 of compliance affidavit, it is stated that target for removal of encroachment has been given. It does not mean that the encroachments have been removed and government has taken and the respondents have taken appropriate steps in this regard. In view of above, we are prima facie of the view that the first respondent, Principal Secretary, Department of Forest, as well as the Deputy Director, Amrut Mahal Cattle Breeding Center, Department of Animal Husbandry, who has sworn the compliance affidavit, are prima facie responsible for non-compliance of the court's directions and filing an affidavit in contrast to the directions issued by the court, and therefore they shall be present before the court on the next date to submit their explanation. Give it.
My lord, would your lordships consider second respondent, my lord, instead of first respondent? Because he is the person responsible, my lord, for all these things.
Give the date.
31-1.
No, we बाद में जो इधर आ नहीं सकते ना तो give date in February.
8-2, my lords. Grateful.
8 February.
Grateful, my lords.
Number 3, Darji Colette.
I appear for the petitioner, my lord, in this matter. The state government has filed its statement of objections on Friday, my lords. Therefore, I request a short accommodation to file
The counsel of petitioner wants a short accommodation to file the rejoinder affidavit to the statement of objection filed by the respondent.
22-2. Number 4, Vinayak B.
Your Lordship, I appear for the petitioner. I seek for a short accommodation in this matter as there is an inconvenience today, Your Lordship. Serial number 4 and 5.
The request of counsel for petitioner for short accommodation adjourned. Give it date.
25-3.
Obliged, Your Lordship. Serial number 5 is also similar to serial number 4, Your Lordship. It may be called together.
Second.
Number 6.
Much obliged, Your Lordship.
AL3.
Yes, who appear for petitioner?
Jayant V.
Shall ask to this, my lord. I appear for the respondent.
Yes. What is the matter?
Lord, the petitioner has filed an application for grant of lease, Lord. That application, Lord, it was granted initially for a period of 5 years. Thereafter, Lord, during the pendency of lease, he has not filed an application for renewal of lease. Therefore, Lord, after the lapse of lease, he made an application for renewal. Therefore, we rejected his renewal application. There is no provision to consider his application. Renewal application filed after the lapse of lease. Under rule, sub-rule 2 of rule 21.
We will adjourn today counsel for petitioner. No one responds for the petitioner. Learned AG is present for respondent. Matter is to be heard finally. Adjourned.
2nd February. Number 7, Shimoga KB.
Yes.
I appear for the respondent.
Is there anyone for petitioner?
This case also we have filed statement of objections. This is also a rejection of renewal application.
Petitioner mic is muted.
So those adjournment matters, no? Say that considering the COVID situation at present. Adjourned. No? Adjourned. Will not pass any adverse order in view of the COVID pandemic situation, and we are only doing virtual hearing.
Yes, Lord.
Adjourned.
16-2.
Same order. No one.
Seal number 8. So Nanja Reddy.
It appear for the last time government advocate took time to file objections. They have not yet filed that.
Yes,
But we have issued a revised demand notice on 13/1/2022.
You are required to file.
Now the challenge.
Statement of objection.
Lord will file, Lord, a week's time may be granted. Since in view of the revised demand, Lord, the earlier
Bring it on
demand may not
record.
survive.
Bring it on record, only then we can consider revised demand. Learned AGM this call is allowed a week's time to file the statement of objection as directed earlier.
Mr. Mahendra, you have to do something about the bandwidth at your office.
I understand, Lord. Today there is some problem, Lord. Otherwise, all these days it was okay. Today there is some problem.
There will be a daily basis to request you to look into it.
Yes, sir. Yes.
16-2. Seal number 9. Neela P. Devadiga.
Serial number 9, I seek for a passover, my lord. Seniors on his legs in the other court.
We will have to pass it over for the day. We want to argue.
Lord, in this matter, we have fast rejection order. This may not survive, Lord. In the year 2017 itself, that has not been challenged in this petition.
I seek for a passover, man.
Have you heard AGS saying it may not survive? What do you have to say on that?
The copy has not been served on us. What Mr. AJ is saying.
It was
the submission has not been served.
passed in the year 2017 and dispatched on 21/6/2017.
Do we have the instructions about this? Whether some rejection order has been passed?
No instructions. That's why I'm seeking for a passover. Seniors on the legs in other court.
All right, passover. Passover for the time.
Number 10.
Appearing for R2, my lord.
I appear for the statement.
Appearing for BBMP R2, my lord.
Appear for
19 July order, Your Lordship.
We are
19 July
yet to receive
2021.
the final needy report, my lord.
They have to file.
Who has to file?
The BBMP has to file, Your Lordship. Kindly
My
see
lord,
19 July order, Your Lordship. 19 July 21. Because it pertains to the Vrishbhavati River Valley rejuvenation. So NERI has given the short-term measures report, 19 July, Your Lordship. There's a committee constituted, 19 July, Your Lordship.
Yes, who appear for BBMP?
Appearing for BBMP, my lord.
Yes.
My lords, our needy is yet to submit a final report. We have not received a copy of it as such yet.
There are already some recommendations made by NERI.
The interim report that was submitted, my lord, there was
what we have done with that?
A final report on it has not been submitted. With regard to the affidavit, we pray a short date. We'll have it filed the next date of hearing. Kindly, this court may.
Now the pollution control board has filed their affidavit, Your Lordship, and also the BWSSB, that is the fifth, they also filed their affidavit. Only
BWSSB, we have filed our report, please. The interim measures and the long-term measures, we have filed, please.
Yes.
I appear for respondent number 4.
I appear for respondent number 5, my lord. We have submitted our affidavit, my lord, after the interim report from NERI is received.
Yes, BBMP, you have to file your response.
My lord, I pray for a short date. At the next date of hearing, we'll have that filed, my lord.
No, counsel for BBMP. Transfer is allowed. 2 weeks time to file the affidavit with respect to the steps, progress made pursuant to the recommendations of NERI and EERI. Give it date.
Subject voted. Yeah. Format to be filed.
AW Council?
Along with council submission, he is asked to replace the board request.
Pass the order for that. I don't understand this.
Mr. Mohan, you will have to file the affidavit.
Your Lordship, the question is that whether that verified affidavit has to file from as the 2020 when the petition was filed or as of today, Your Lordship.
But there is a difference in 2020 and now.
Regulation come into force, subsequently notification issued, Your Lordship, that's why.
File an affidavit in terms of the performer that you have no personal interest.
Because it has been already notice has been issued and all this court is monitoring. That's why I asked for clarification, Your Lordship.
Please file it, because the rules are there.
Yes, no rules are there, Your Lordship, I know. But what is the date? Because earlier it was not there when this petition was filed.
When will you file this, Mr. Mohan?
It is in 2020, Your Lordship.
When will you file the affidavit? Please file it on this also.
Now, within next hearing date, I will file it, Your Lordship.
Sri Mohan, counsel for the petitioner seeks for a week's time to file the necessary affidavit in terms of Rule 14.2 for the High Court of Karnataka Practice and Procedure for PIL, Rules 2018. Time is so granted.
3rd February. Please.
My lord, I appear for the petitioner, my lord.
Ravi?
I appear for the petitioner, my lord. Lord, the constitutional validity of Karnataka Regulation of Stone Crushers Act is called
The
in
last
question.
date we were informed and learned Advocate General would address the court.
Correct.
Yes. Yes, Lord, we have filed a statement of objections, Lord, in this matter. And at the same time, Your Lordship has direct affidavit pro forma, Your Lordship may kindly see. Pro forma A, as per Rule 14.2 of High Court of Karnataka.
That day, file, Mr. Mohan, are you ready with the matter?
Are you ready? Are you ready to argue the matter?
Yes, Lord, I am ready.
No, Advocate General need not to come.
I may be permitted to submit, Lord, because it is covered by the judgment of this Honorable Court. The validity of the regulation for Stone Crushers Act has been upheld by this Honorable Court. We have produced along with our statement of objections.
That is incorrect. None of the grounds urged by me are either raised or considered in the earlier order.
Only ground on which, Lord, the petitioner is maintaining this petition is that, Lord, legislative competency of the state in enacting this act. Lord, he the petitioner is misconstrued, my lord, that the regulation of Stone Crusher Act is with respect to mines and minerals. This has nothing to do with mines and minerals, my lord.
The petitioner could look at it.
Your last may kindly see the ground, the first ground, the only ground, sole ground urged by the petitioner is that, my lord. Para 7, page 7, page 11.
Mr. Vaidya, you file your affidavit.
I shall file it, my lord. In fact, I had asked my client, my lord, he is in Belgaum. Due to this pandemic situation and increase in COVID cases, was not able to travel. Lord, may I seek my lord's indulgence for 2 weeks, my lord?
Yes.
So that he may be able to come here.
Vaidya Learned Counsel for the petitioner seeks for 2 weeks' time to file necessary affidavit in terms of Rule 14.2 of the High Court of Karnataka Sponsor Act. Granted. Do you want to file any rejoinder?
I shall file, my lord. I shall
To file rejoinder, if any.
Sir, February.
Grateful, my lord.
Number 12, to Nikhilesh Rao.
I appear for the petitioners, my lord. My lord, in this matter, we had filed an impleading application seeking to implead the Union of India since central legislation has been challenged, my lord. And we've, pursuant to the directions of this honorable court, we had served copies of the petition as well as the applications upon both the offices of the Learned Advocate General as well as the Learned Solicitor General, your lordship.
Appearing for the union? Shanti Bhushan?
I shall inform this to my lord. This is a matter to Shanti Bhushan, my lord.
We have to formally allow the application and then take it up, Mr. Rajshekar.
Please, my lord. I'll do it, my lord.
The petitioner has filed an application. Simply, the Union of India is a party respondent in view of the fact that the central enactment has been challenged. That application has also been served on the Council for the Union. However, none appears. Considering that the central enactment has been challenged, we are of the considered opinion that the Union would be an IA2 for 2021 is allowed. Petitioner is directed to carry out necessary amendment and file amended cost status.
Much obliged, your lord. A date may be granted, my lord.
In this matter, copy of the writ petition is not served on us.
My lord, we have served it, my lord, and the memo of service has also been filed, my lord.
Petition along with all annexures on the councils for the respondents, if not already served.
8-2.
Obliged, my lord.
Obliged.
Number 13, Subramani.
Lord, may I make a submission, my lord?
Yes, Mr. Shanti Bhushan, the earlier matter.
Please.
We allowed the impleading application, so if you have any objection, you could file the objections.
Please.
My lord, in 13, my lord, I appear for the petitioner. My lord, the petitioner's application seeking consent for operation has been rejected by the Respondent Pollution Control Board. My lord, next, A is the order, page 18. My lord, my application has been rejected on the ground that the sufficient documents in respect of the land has not been produced. My lord, even after passing of this order, my lord, I have submitted certain documents, my lord, as per Annexure X. My lord,
after passing of the order, Mr. Subramani, if anything is submitted, there is no value for that.
Please, but my lord, this is only, my lord, the Pollution Control Board found only this reason. My lord, my industry is, my lord, fit for running the industry in all other respects. My lord, this could not have been a ground. My lord, if I am violating any of the pollution laws, my lord, that could have been a ground. My lord, here, my lord, I have produced the document. I have produced the lease cum sale agreement given by the pollution KIADB. And even I have produced the possession certificate.
Issue notice to the respondent that counsel for the petitioner is also permitted to serve the.
My lords, may I make one submission?
Accept notice, Mr. Chaudhary?
Yes, my lords, I will accept notice.
Yes, Chaudhary.
Lord, standing counsel for respondent, accept notice.
I'll serve the notice. Obliged.
54. Serial number 14.
My lords, serial number 14, I am appealing for the petitioners, my lords.
Happy for the state.
My lords, if I could seek for a short accommodation as I have been tested COVID positive and have been quarantined.
18-3.
Obliged.
15.
My lord, I am appearing for petitioner, my lord. In serial number 15. I am praying for 2 weeks' time, my lord.
For what?
My senior is not feeling well. So kindly be having 2 weeks' time, my lord. Then he will be in position to come out.
Urgent.
25-3.
Much obliged.
Number 16.
I appear for the petitioner, my lord.
I appeal for the state.
I beg to paper, impleading applicant, my lord, who filed the application, my lord, so as to in respect of the petitioner schedule B item, my lord, survey number 94 concern, my lord. Previously, the Honorable Court was pleased to direct the authority to do this survey, my lord. And today, they have not placed that survey, my lord. In the meantime, the respondent authority, that is Tasdar, wants to demolish our religious building without any notice or without any direction of this Honorable Court. This Honorable Court in previously, my lord, gave the protection order, that is order dated. That is.
Who appears for the state?
But I appear for the state, Lord.
Always come that, madam.
Lord, the land belongs to government. Church has been put up, my lord, in the land belonging to the government without any authority of law. No permission is obtained. No grant is made. A report
The server, because the earlier order is saying that you should come up the server and place it before the court.
by a memo dated 26th August, Lord, we have placed before your lordships the report given by the Lord Tashildar after the survey. Lord, there is a sketch also, Lord, and paragraph 3 of the report may kindly be seen, Lord. They have no locus standi, Lord. Lord, the 26/8/2021, Lord, we have filed a compliance memo. Along with that, there is
Just a minute. Compliance 24/6/2021.
26/8/21, my lord. On that day, they sought for the 4 weeks time to carry out the survey, my lord.
26/8/2021.
kindly see paragraph 3 of that memo, Lord, the report.
I will furnish a copy of this to the
That copy not at all served on me, my lord.
I cannot serve on an impleading applicant. He
How
who is
can he
coming up
be-
before the court now, who has no locus standi, Lord.
My lord,
Government land, Lord, no authorization.
Who appears for the petitioner?
I am appearing, my lord.
You are not saying anything.
No. They were saying, so I did not want to interfere. The sketch is produced, my lord, by the state, wherein they say categorically that the land is on the government land, no kind of permission is granted, and it is totally an illegal construction. Your lordship may kindly go to this sketch.
My lord, one submission, my lord. Previously, my lord, the Honorable Court categorically granted the not to demolish the.
No. That's a different order, Lord, in respect of different survey number.
15/3/21, my lord. 15/3/21. The Honorable was pleased to grant an order of not to demolish. Thereafter, my lord, we filed in the impleading application.
Mister, who are you?
My lord, I am the impleading applicant wherein the land is granted to me. I produce the annexure R3, my lord, along with my application IA number 3. The copy of the grant certificate in respect of the survey number 94 dated 18/10/78, my lord. Based on that, my lord, thereafter,
That is the land is granted to this applicant, my lord.
All right.
In that land grant itself, my lord, there is a building is there, my lord. For that, my lord, the Honorable Court was pleased to direct the authorities to do the survey. Yet today they will not give the either survey notice to us or not give the survey. What are the copies are given to us, my lord?
As per court order, the date was informed for survey as 26th of April 2021 by the Tehsildar. And this was noted by the court, and direction was issued to the parties to the case to be present on the date of survey.
Yes, my lord.
And thereafter survey was done and this report has been submitted.
Because we are not at all.
There is no question for you to be given notice.
Because, my lord,
you are not party to the case.
Yes, my lord. My lord, kindly previously the application before this Honorable Court in this writ petition, that application is still pending. This Honorable Court directed informed that after getting the report, they will consider the application of impleading application, my lord. That is a specific order is there, my lord. Just
which order?
That is, my lord, in that is on 7/4/21, my lord.
Yeah, after survey report,
as regards IN number 321, the memo filed by state government February 21, records of further survey, land survey is not yet completed. We direct the state government.
In accordance with law, whatever action is required, why we should listen? We can just I'm saying this. No, they have to, in accordance with law, they have to act upon it. It may be allowed. We have heard.
Because, my lord, what the structure is there, it is in the granted land, not in the government land. Because that's why, my lord, I request that what is the survey report. For that report, I can file the necessary objection.
All right, whatever they feel like, if they feel that it is an encroachment over the government land, they will act in accordance with law. We will give you notice, opportunity, and everything, and thereafter act upon it.
They are not given any notice, my lord. They already
all right, we will direct them. We will provide that. We will provide that. Now that survey report has come, this petition can be disposed of on this.
No, my lord, on submission. For petitioner, my lord, one is the granted land is different. The church is constructed on a different land. The survey sketch and the Tahsildar report makes it very clear. That apart, my lord, this writ petition pertains to the construction of religious structures in another village also. That is still to be decided. So it cannot be disposed of because there is one more village, my lord, where one three villages
for forfeit, demolish or illegal construction structures on the properties mentioned in schedule below. So there are other properties also.
There are one more village, there is 3 properties that has to be decided, my lord.
But your lordships may kindly have this matter on Monday, blood. I shall file a detailed status report complying with the blood interim directions issued by the Honorable Court. Because this has been moved, Lord. Otherwise, Lord, we would have filed the report. In both the cases, Lord, we have taken necessary action.
I requested that copy, my lord, to what is the survey copy?
Applicant, we will not. Lordships may kindly appreciate that. He has no locus standi, Lord, to come up before your lord.
No. Already there is a direction by the Honorable Court. After survey, my application will be considered. That's why what is the survey is done by the authorities, that copy has to be looked into. Because, my lord, what they alleged that
all right, we have considered your submission. We will consider your submission.
Because, my lord, what the apprehension of this applicant is that now the Tahsildar issued a notice. Even yesterday also he come to our building.
All right, listen to the order. Learned AG informs that compliance memo has dated 26 August 2021 has been filed, indicating therein that the survey conducted by the Tehsildar, it has been found that the church has been constructed illegally without obtaining any permission from the revenue authorities and without obtaining conversion order, and the said church has been constructed in government land a sketch of map has been annexed with the compliance report. The Lordo Morepa Learned Counsel, appearing for the implement application filed on behalf of Kishore Kumar SR.
Not Kishore Kumar, sir. My lord, Anumappa and
this is Kishore Kumar.
He is the petitioner, my lord. Kishore Kumar is the petitioner.
Anumappa and Jayaprabhu, my lord.
Who is the applicant?
Anumappa and Jayaprabhu. IA number 3, my lord.
Ayappa and Jayaprabhu submits that the court-wide order dated, which is order? Seven 4/21 had observed that after filing of survey report, the implement would be considered, and therefore he has a right to be heard. The right is submitted that the construction of church has been carried out on the
Granted land, ma'am.
Granted land
To the Anumappa in the year 1978 itself. We have produced the grant certificate also, ma'am. To that effect.
The grant certificate.
Annexure R1, my lord.
Has been brought on record as R1. Full stop. Para. Be that as it may. It is for the authorities concerned to take appropriate steps in accordance with law in case they found any encroachment over the government land, and it is needless to observe that the authorities, while removing the encroachment over the government land, shall adhere to the procedure prescribed for this purpose, for the removal of encroachment, and may issue notice to the encroachers before taking any decision to remove the encroachment.
My lord, kindly direct the authority to serve the that survey report, my lord. We will look into if that is any adverse.
The respondent shall file the status report on the next date. Give a date after 1 month.
My lord, one submission, my lord. Regarding those copies, survey copy, kindly direct the authorities to serve on them. Otherwise, without that copies, it is helpless to us to know that what is the authority what is this.
Go and get it under right to information.
My lord, we filed the necessary application already. They are not given, my lord.
Will not complicate the issues unnecessarily. Yes.
Otherwise, we are this applicant since last 17 years that even the Katas are in the Gram Panchayati record, my lord, regarding this building concern.
Submit before the authorities all that. We have said notice would be given to you.
Number 17.
No, my lord.
I appear for petitioner regarding both the cases.
There's one more case, my lord. Serial number 40, WP 14854, tagged with this case.
Yes.
That has to be heard, my lord. 14854, my lord.
But in that, your lordships have already directed us to file a status report, my lord. We will file it because the matter was scheduled for 25th.
In the connected matter also, right, the London AGI is directed to file the status report.
My lord, one submission, my lord. The state has filed an affidavit stating that the Hakkupatra issued is bogus, genuine, not genuine, and the construction is totally illegal, my lord. So the nothing survives there, my lord. Only removal of the disputed structure.
Let the status report be filed, we will consider.
Much obliged, my lord. Much obliged.
17.
No, 17. Lord, in 17, Lord, I have filed a memo, Lord, seeking permission to delete prayer 2, Lord, that is challenge to the rules, Lord.
Yes, who appear for the, you are for the petitioner?
Yes, Lord. There is some urgency in the matter, my Lord. That's the reason I moved this matter.
So let this be.
We'll file our statement of objections, my lord.
What objection? We will permit this. He does not want to press the prayer number 2. What objection you can have on that?
That could be done.
Let the matter be listed before the appropriate court.
Please.
Considering the urgency in the next week. Where is your memo? Where is your memo?
Lord, in 18294, Lord, after IAM, Lord, it is there. IFR posting, it is.
The Learned Counsel for Petitioner informed that he has filed a memo for permitting him to delete prayer number 2 in the writ petition. The prayer number 2 is with respect to the challenge to Rule 2 in bracket small g, Karnataka conduct of entrance test for selection and admission to postgraduate medical and dental degree and diploma courses amendment rules 2013. Full stop. Memo is allowed. The counsel for petitioner is permitted to delete the prayer number 2 from the prayer column. In view of the fact that now there is no challenge to any rule, regulation or act, this writ petition as such, the office may list the case before the appropriate bench dealing with the matter in the next week.
Lord, not next week, Lord. Now, from today, Lord, they have started process of admission, Lord. I will move the appropriate bench, Lord, and try to convince
will
the
not
court,
say
Lord,
anything,
regarding
you move a
urgency.
memo. Will not say anything, you move a memo before the appropriate
Yes,
court.
yes, Lord. Yes, Lord.
Place before the appropriate bench only. Huh?
Please. In both the cases, Lord, there are 2 cases.
17.1 also same order.
Please.
In that also you have filed the memo.
Yes, Lord.
Same order.
Number 18, single case.
Lord,
in 18 minutes, I represent BBMP and I have received copy on 10th of this month, Bharat. I have sent to the corporation, I have no instruction. Kindly grant me 2 weeks time, Bharat, we will file the statement of objection.
My lord, I appear for the petitioner in this case. My lord, the interim order says I have to comply with the interim order within 2 weeks. If the Learned Counsel for BBMP
furnishing a bank guarantee for the levy of the period covering 2021 and 21-22 within 2 weeks.
It is a commercial institution. They are asking for exemption from payment of tax. There is no such provision in the Act.
My
Go and comply. Go and comply.
My lord, the reason why I
failing this, not only interim order stand rescinded, but the writ petition runs the risk of being rejected.
My lord, why I have filed this application for modification of interim order is I have paid taxes, a certain amount of taxes which I have furnished along with the application at page number 7 and page number 8, my lord. I am only asking
not even 5%. That is not even 5%.
Has to be before the same bench.
Yes.
I'm only saying that amount which is already paid may be considered for and reduce the bank guarantee amount. That's the only thing I'm asking.
No, it's not correct.
Lord, what I am saying is I have already paid certain amounts. I'm only asking to reduce that amounts in the bank guarantee, my lord. That is the only thing I'm asking, my lord.
How can we get into the calculations, Mr. Chandan, now?
If you want to take the benefit, do it. If you want to take
my lord, in that case, I would at least seek an additional 1 week's extension of the interim order, my lord, in which period I will comply with the interim order.
Right. The Puttagada will also not have any objection for that as long as he gets it.
that we can grant you 1 week for that time.
Much obliged. Much, because here it is 2 weeks, my lord, so I'm seeking another 1
No,
week.
he has 1 week, now he is shifted to 2 weeks.
No. I said 1 week only, my lord. I said I spent some
1
time
week, we will grant you 1 week for that time.
Please.
Much obliged. Much obliged.
This is an application for modification. Where is that?
Interim order 29th December 21.
This one. Modification of interim order dated 29/12/2020 passed by this court.
There within
The
2
counsel for
weeks,
the petitioner
the Honorable Court granted 2 weeks in the month of December 21. Now, it is already 4 weeks, is almost over.
29 December, Mr. Puttagada.
29, yes, madam. All right, 1 week, kindly.
Then the counsel for the petitioner applicant at the very outset submitted that that the period of 2 weeks may be extended by further 1 week in order to comply the interim order. Then the counsel for respondent have no objection in this regard. The interim order dated 29/12/2021 is extended for further 1 week for the purpose of allowing the petitioner to furnish the bank guarantee for the levy for period covering 2021 and 21-22.
Much obliged.
Application stand disposed of.
Much obliged.
Number 19.
Lords, I think plus this matter is covered by the earlier petitions bearing number 518 and of 2022 and 319 of 2022. Lords, this is in reference to Mekadatu thing which was got disposed.
The possession matter one then put it.
The petitioner submit that the relief sought for in the present petition is already covered by the order of this court in WP number
518 of 2022. WP number 319 of
2022. Obligement. Above petition also disposed of in terms of the said order.
Yes, obliged.
Also matter number 9.
I appeared for petitioner. Your Honor. I sought for a direction to grant the mining lease. I filed an application on 14/3/2017, Your Lordship, which has been not considered by the respondent. Therefore, I filed a writ petition seeking direction to consider it. Now,
the permission made by valid AGO was that it's already been rejected.
Your Lordship, they have not served the copy. May I request Your Lordship direct them to serve the copy?
We'll record their statement. We'll record their statement and dismiss the petition with liberty you to challenge the same.
May I?
Before they no purpose served keeping this petition pending now. It has now, since the rejection has been done, you will have to challenge the same.
Because they say that 2015 it has been dismissed. They rejected my application. My application, in view of the amendment to the MMDR Act, 2015 amendment, Your Lordship, my application survives. So if that is rejected in the year 2015, Your Lordship.
Rejected, you will have to challenge the rejection, man.
Yes. That is true, my Lord.
The petition has been filed seeking following relief. the learned AGA, appearing for the respondents on the basis of instruction submit that the application for grant of renewal of license of the lease of the petitioner
And
in respect to the land 83.17 acre in survey number 84 of Kondli and survey number 9 of Mullapalaya village, Gubbi Taluk, Tukur district has been rejected in 2017. When it has been rejected?
2017.
5/6/2017. On 5/6/2017. 5/6/2017.
5/6/2017. In view of above, the building trade cannot be granted. The writ petition is accordingly dismissed with liberty to petitioner to challenge the rejection order
Your Worship, direct them to serve the copy, Your Worship.
before the appropriate forum.
Your Worship, may I request for serve, because they have not served the copy. Your Worship, may kindly direct them to serve the copy.
amendment is pending.
Navagaran.
Sir, court officer.
One to 4 and 6 to 7. Place for adjournment on the ground that the arguing counsel is unwell. Let's start for 2 weeks.
Grateful.
Serial number 20, my lord. The counsel for the appellant has no objection to the prayer for adjournment. Let's start for 2 weeks.
My lord, serial number 20, my lord. I am respondent. I want to file my objections. I need 4 weeks time to file my objections, my lord.
Serial number 20.
Yes, my lord.
Who is for the petitioner?
I am for the petitioner, my lord. I have no objection.
Oh, yes. Now the presence Mr. Ramesh Upadhyay, learned counsel for the petitioner. K. Narayan Swami, learned counsel. Respondents, place for Mr. Ranjit.
Lordship, serial number 12. 22, my lord.
Oh, yeah, all of you are in a hurry. We thought, yeah, all right, yes, please. 22.
22, my lord.
Yes.
Wow, 1 week may be granted, my lord.
No, you are appearing for petitioner.
A petitioner, my lord.
Who is for respondent? Yes, Mr. Government Advocate.
One.
Serial number 19, my lords.
Wait. No.
On that.
What is this?
Next week, my
Beginning
lord.
to the new year is unexpected. With so many adjournments, right? At 10:30.
My lord.
No, we said that beginning to new year.
1 week, my lord. I read translation and judgment enough, sir. 22, my lord.
This is 2012 matter, Mr. Direct counsel for the petitioner. Raised for adjournment. File of intelligence, hearing of the petition paper, list after 1 week. No adjournment, list on the next week. Yes, next.
Permitted to mention one matter.
Your Lordship, serial number 27. 27.1, 27.2 connected matters, Your Lordship. I see 2 weeks adjournment, Your Lordship.
First of all, you should tell us you are appearing for whom?
Respondent.
Have you informed the counsel for revenue?
Yes, Your Lordship, I have informed.
You informed Mr. Arvind?
Not informed, my lord. I'll leave to your lordships, my lord.
Yes, Mr. Arvind, what do you say?
Lord, not informed, but I'll leave to your lordships, my lord, so far as adjournment is concerned.
When she is praying for adjournment, do you oppose the prayer?
Next week, my lord. Next week, your lords, my lord.
Yes, madam, please argue next week.
Yes, Your Lordship.
87.
Your Lordship.
KVR is learned counsel for the revenue. Right surname, learned counsel for respondent. Learned counsel for the respondent, place for adjournment. List next week.
Your Lordship, I may be permitted to make one submission regarding serial number 29, Your Lordship. I'm appearing for the respondent. Your Lordship, my senior, Mr. A. Mahesh Chaudhary, had to go for a COVID test as his cook has been tested positive. I have informed the Revenue Department Council also regarding the adjournment, Your Lordship.
Next week?
2 weeks, Your Lordship.
Yes, Mr. Arvind.
Please, your lords.
Mr. Arvind, KV, learned counsel for the revenue. Right surname, learned counsel for response. Place for adjournment.
Your Lordship, serial number 31.
List after 2 weeks.
Grateful, Your Lordship.
Your Lordship, serial number 31. I am for the petitioner, please, my lord. It's a habeas corpus petition. Your Lordship, the detainees have been arrested formally, please, my lord. So I would request this court to dismiss it as withdrawn, please.
The Umar Sharif Learned Council.
Yes, please, my lord.
Presents Learned Council for the petitioner submits that subsequent to the filing of the writ petition, the petitioner has been arrested. He therefore seeks leave of this court to withdraw the writ petition. Accordingly, the same is dismissed as withdrawn.
Obliged, please, my lord.
My lord, may I be permitted
Serial
to
number
mention
19, my
one
lord.
matter, WP 21547 of 20.
Wait, madam. Here, 110. For mentioning, let us proceed serially now. It will reach 19 within.
Your sign for petition is 19.
Why don't you first? Why are you waiting?
Number 1, for admission, chamber 1, Sri Prasanna
I appear for the appellant in this matter. Now, this is an appeal under Section 21 of the National Investigation Agency Act, filed by the National Investigation Agency, challenging the order of the learned special judge, granting bail to 4 accused persons who are involved in illegal trafficking of about 38 Sri Lankans. Though order was passed in the first week of December 2021, the accused will not continue. I have made an application for interim stay. The accused will not continue to be in prison. The accused will not continue to be in prison for the reason after the order on bail was passed, they made 3 attempts to furnish sureties with fake documents, in respect of which the learned trial judge is proceeding to register 3 different cases on this appellant.
No, we'll consider your prayer only after notice, not expert. Mr. Prasanna Kumar P. Learned Counsel for the appellant, notice on admission as well as IA1 of 2020.
Please.
Number 2, the agreement writing.
For the petition, my lord.
For the respondent number 3 and 4. I'll say I filed the acknowledgement in the course of the day. Acknowledgement, I'll serve it on the other side, my lord. The IA is served. I'll file it in the course of the day. On 16th December, my lords have dismissed the petition for non-prosecution. 9th December 2021.
Yes, who appears for their representative?
My appearing for the respondent number 3 and 4, my lord. I have no objections to settlement.
Not the presence on.
And directed to appellant, my lord, to serve the copy of the writ petition.
Petitioner submits that he shall comply the office of objection during the course of the day. Heard on IA1 of 21. For the results assigned in the application, which is duly supported by an affidavit, order dated 9/12/2021, is hereby recalled in the result WP number 36942/2016 is restored to file.
Obliged.
Yes,
appearing for the respondent.
Company and shareholder for the second respondent company. The company is also the shareholder. Some disputes have been resolved now and complete. There is only one submission, the office objection raised that how this OEC is maintainable. I am a party through and through. And because my name doesn't appear in the cost
It's not audible, Mr. Counsel.
but objection has been raised.
Also, please check your audio. It's not audible.
You are not audible. Please speak into the mic.
One moment.
Your voice is not clear. There seems to be some error in your instrument. Your voice is not clear.
My lord, I am appearing for the respondent. The matter is settled between the parties, my lord, and filed a compromise petition and also joint memo, my lord, for withdrawing the petition, my lord. So maybe lords may.
So he wants to ask him whether he wants to withdraw the appeal.
If the respondent counsel says the petition is compromised, do you like to withdraw the petition in terms of the compromise?
There is no question of withdrawing the petition. I am saying that perhaps we have, my shares have been purchased by the state government for 68 crores. I have received the money. let the matter be closed, that's all. All that I am requesting your lordship says that kindly overrule that objection that the vote is not maintainable. Number one.
Are you disputing the compromise? Are you agreeing the compromise?
Whether we have signed the compromise, we have signed the compromise, and also we have compromise, a memo, a joint memo, saying all the terms and conditions have been fulfilled.
The terms of compromise dated 30th October 2021 can be accepted. Please.
Yes.
That is the issue with regards to the maintainability of the appeal. It's something.
The maintainable appeal. What about the maintainable appeal?
Milord, that is, Milord, the High Court, the registry has raised that we have filed, in any case, filed an IA, a third party IA, kindly allow that IA and overrule the office objection.
What is IA1?
IA1, Milord.
That is written.
No objection, my lord, because my lord, that's the application is, the petition itself is filed by one of the shareholder, my lord. The OSA is maintainable, my lord. They have filed an application also. So I have no objection, my lord. The application may be allowed and compromise may be recorded. Please.
Word on IA1 of 21, an application seeking permission of this court for filing leave to seeking leave to file an appeal. Full stop. We have heard the lead counsel for the parties. The lead counsel for the appellant submits that the appellant is the shareholder, and therefore the appeal at the instance of the appellant is maintained. For in lieu of official submission, IA1 of 21 is allowed. The office objection with regard to maintainability of the appeal is over. Also heard on IA1 of 21, an application filed under Order 23 Rule 3 of the Code of Civil Procedure. When it comes for the parties submit that the dispute in this appeal has been resolved between the parties subject to the terms and conditions mentioned in the compromise. It is further stated that compromise petition has duly been signed by the parties. After perusal of the compromise petition, we are inclined to accept the compromise petition. The appeal is disposed of in terms of the compromise arrived at between the parties, which is reproduced below for the facility of reference. Clause 9 onwards, each schedule. Accordingly, the appeal is disposed of.
Milord, your lordships took the compromise petition on record, Milord, and also the joint memo. Joint memo. Very well.
We have taken on record and we have reproduced also the terms and conditions.
Very well. But there is a joint memo filed that the compromise petition was subject to certain conditions which have been complied with subsequently by the parties, and they have filed the joint memo.
Then say it is learned counsel for the parties while inviting the attention of this court to the joint memo submitted that the terms and conditions set out in the compromise petition have already been
duly complied with, yes.
My lord, there was an interim stay was there, my lord, on the utilization of the land, my lord, because of.
You know what happens when the.
Much obliged.
Please, your lordship. In this case, the petitioner has questioned the order of detention under the Karnataka High. Additional grounds had been raised. In view of it being a habeas corpus petition, strict rules of pleadings, etc., are not applicable. Your lordship may allow this application and hear the matter with these additional conditions.
Mr. Kiran is only learned senior counsel. So and so heard on IA 1 of 21. For the reasons assigned in the application, same is allowed. Let amendment be made within
2 days, my lord.
Within 2 days, learned additional government advocate praise warrant is granted a week's time to enable him to file amended statement of objections if so advised. List on which date, Mr. Next week, Mr. Javli.
Please, your lordship.
Which day?
First or second, your lordship.
2nd February. Next on 2nd February 2022.
Obliged.
Number 5, CM Lava, CE.
May I please, your lordship. May I please, your lordship.
Yes, Mr. Shankar. Yes.
It's been complied on 20th of last month itself. Unfortunately, the acknowledgement could not have been filed. I have filed it in the morning today, my lord.
Mr. Shankar Lalit, Senior Counsel with Mr. Lava and submits that the office objection has been complied with. And the acknowledgement has been filed today.
Today, my lord. Today, my lord. Yes.
Acknowledgement has been filed today. Accordingly, the office objection is removed.
That's it.
Please, your lordship. Matter arises under the Coffee Posa Act. They are ready for final discourse.
Appeal for the respondent, my lord. Appeal for the respondent. Yes, my lord.
Ready?
Ready, my lord. Ready.
We'll take it up. Please wait.
Please, your
just go finish the other matters and then we'll take up your case.
Please, your lordship.
Number 7, C. Sharana, yes.
Lords, appearing for the petitions council in this matter, my lords.
Yes.
Lords, I have served the respondents council, my lords. Now the contesting respondents for the instant case will be, my lords, the 4th respondent and the 5th respondent, and 6th respondent is the authority, my lords, which is required to inculcate the seats in for counseling. Notes the facts leading to this case is that the petitioner being an existing 100 intake.
Ravi Shankar, there is some office objection, non-compliance, furnishing of process fee, etc. They have not been solved.
Notes their names are not shown because I have already served them. Notes the urgency is that the counseling has already commenced. Notes the NMC, after inspecting, records a finding that they have the infrastructure and instructional facilities for 250 seats. But without assigning any reasons, it is approved only for 200 seats. Lords, I have this matter day after tomorrow, my lords. I will, by showing the name of, lords, N.K. Ramesh appears on behalf of respondent numbers E, 4 and 5.
Okay. Office is that Mr. D.R. Ravi Shankar, Larish, Senior Counsel.
3 and 6.
Amidst that the copy of petition along with annexures has already been served on Mr. N.K. Ramesh.
N.K. Ramesh appearing for 3 and 6. 3 and 6.
Who represents
and Chetty.
3 and 6. Right?
3 and 6. And Chetty appears for 4 and 5.
As well as Mr. Chetty, who appears for respondent number 4 and 5. Office is directed to reflect names of so and so and so and so as counsel for respondents 3 and 6 and respondents 4 and 5. List on 27th January.
Lords, it will go to next week. Lords, the counseling is already commenced. If the seats are not inculcated, Lords.
Then tomorrow, please inform. We will take up tomorrow.
Not this matter. I have this matter tomorrow, Lords. I'll keep both of them informed.
Based on 25th January 2022.
Great. What is on next?
Number 8,
Your Lordships, I appear for the petitioner in this matter, Your Lordship.
What is it?
Your Lordship, the matter was listed on 20th of September 2019 and 4 weeks was granted for complying with the office objections. However, one of
grabbing, madam. Hand grabbing. What is the petition?
Your Lordship.
What is the prayer, madam?
Hand grabbing. Quite sure.
Now there is an appeal, right? Madam,
Yes, Your Lordships.
in the repetition, you seek quashment of an order dated 18th of March 2019, passed by Karnataka Land Grabbing Prohibition Special Court, right?
Yes, Your Lordship.
Now, by way of an amendment in the Act, an appeal lies, right? Whether that right of appeal is available to you.
Your Lordships, I have to verify. I will.
Before filing an application for recall, you should have verified, no? If an appeal lies, then we would grant the liberty to you. Where is the amendment? Mr. Natraj, Karnataka Land Grabbing.
Your Lordship, I will comply with the office objections if the order is recalled and then.
No. Yeah, just please see the Act. Review special court. And there is a police to appeal. Very often.
Latest still one. 2017 amendment.
17 amendment. There is a provision for an appeal, no?
Yes, ma'am.
You know, madam. It has come into force from 19th October.
19th October 22.
So, madam, under section 17A of the Act.
Yes, Your Lordship.
You have a right of an appeal. All right, we'll list the writ petition tomorrow. Please examine it. Huh?
Yeah, obliged, Your Lordships. I'm a proxy counsel, Your Lordship. If it's listed tomorrow, I verify and I will ask the counsel on record to make submissions.
Proxy doesn't mean that you can claim right to ignorance, right? Please see, we are telling you 17A has been incorporated by way of an amendment in the Act. It provides for an appeal. So we have passed orders in several cases. We have relegated the parties to remedy of an appeal, right? You have to file an appeal. So
kindly
file your application. It will come up tomorrow or day after, whenever, right? 27. Word on IA 1 of 20. The reasons assigned in the application will be supported by affidavit. You find that sufficient cause for conveyance to delay of 142 days in finding the India is allowed 2 of 20 allowed order dated 20th September 2019 is recalled. Let verification be listed for order from 27th January.
Grateful, Your Lordship.
Number 9. Serial number 9, first matter. Mr. S.N. First matter, Mr. S.N. Prashant Chandra is appearing for response number 5. Therefore, kindly direct the office not to show my name.
Lords, kindly, please, my lords. Serial number 9, please, my lords. I appear for the respondent number 3 and 4.
Just a minute. Just a minute. But in the first matter,
and that day I was on leave, my lord. The Lordship's court officer only sent that. By mistake, he has not sent the wallet properly.
Why these cases are come up?
No, it is specially ordered, my lord, before your Lordship one.
validity, wires of the.
How it is coming up before
wires of DWSS Act.
Before Portal 1. Last week onwards, it is coming up before Portal 6. Virus, challenging virus. But this is by special orders. It will come up before your Lordship only. Before quarter number 6, this is by special orders before your lordship.
Yes,
Mr. Virus, my lord.
In the first matter, my lord. In the first matter.
Just a minute, 89A, please, my lords, the BWSS Acts, please, my lords, 1964 is under challenge. Pro rata, please, my lords, and beneficiary capital contribution.
Yes, Mr.
I'm for
in the first matter. Just a minute, my lord, in the first matter, Mr. S.N. Prashant Chandra is representing BBMP R5. Therefore, kindly direct the office not to show my name, my lord.
Where is Mr. Prashant Chandra?
Appear for Prashant Chandra, my lord.
Yes, madam.
Your lordship, my senior is not keeping well, my lordship. I seek for an leave subject.
Let's discuss.
Next week.
May I make one submission? There are about 100.
There is an interim order in your favor. What's the problem, Mr.?
May I make one submission?
There are about 100 matters, my lord.
There is an interim order in your favor, right?
Yes, ma'am.
Then?
With my lord's indulgence, can I make one submission?
Yes.
My lords, my humble submission is about 100 petitions are filed totally, please, my lord, seeking to challenge the constitutional validity, please, my lords, as also the implication of the notification. And, my lords, the notice, my lords, calling upon, please, my lords, the various builders, please, my lords, to pay, my lords, BCC charges, pro rata charges, as also NOC charges. And now, please, my lords, as per the NGT order, there is this treated water for construction purposes. We are, my lords, charging that also, please, my lord, that is also under challenge. My humble submission is, please, my lords, the pleadings will have to be complete, my lords, in the later on petitions where constitutional validity has been challenged. I pray for about 2 weeks' time, please, my lords, I will complete these pleadings. Secondly, all these matters will be listed. I appear for BWSS, please, my lords, the respondent number 3 and 4.
Council for respondent 3 weeks time.
For respondent number 5,
Hello.
Malad, in the first matter, kindly direct the office not to show my name.
Office is directed to delete the name of Mr. K.N.
Let's can I request, my lords, for a date and second week of February, please, my lords, so that on that day it could be heard and disposed of. There is some urgency also.
So you first file objections, thereafter we'll see. You first file, we have granted you 3 weeks time, first file objections.
Grateful.
Let the pleadings be complete. Date can always be fixed.
Please.
Because 10 also.
10 also same. 10 also. Interim order needs to be extended.
Interim order can continue. Yes.
My lord,
I appear for respondent,
my lord, serial number 11, my lord, appearing for the appellant. My lord, I seek most humbly adjournment for 2 weeks, my lord, because a very close relative of my senior is very sick, as well as several associates in the office have tested positive and the office is not functioning currently, my lord.
For the petitioner pays for adjournment. Appellant pays for adjournment on the ground that the arguing counsel is under. Just after 2 weeks.
3 weeks, my lord. After 3 weeks or 2?
2 weeks. 2 weeks.
2 weeks. Problem.
Number 13, Sri K.V. Arvind. Number 12.
Serial number 12.
Number 12.
Serial number 12. I'm requesting for a week's time in this case, my lord. My wife is tested COVID positive. Slight inconvenience is there. It may be posted next week, my lords.
The counsel for the petitioner pays for adjournment. Yes, next week.
Serial number 13, my lord. The questions, my lord, are page number 8 to 10. My lord, 4 questions are there. My lord, the first question, my lord, as of now, my lord, it is decided against me. Your lordship kindly consider to admit, my lord, only question number 2, 3, and 4, your lordships. At page number 9 and 10, my lords.
Good on the question admission. the appeal is admitted on following substantial questions of law. 2, 3, and 4. Huh?
Please, Your Lord.
14.
Lord, serial number 14, my lords, it pertains to transfer pricing issues, my lords. My lords have previously admitted a batch of matters, my lords. They framed the questions of law at page number 8 and 9. There's 4 substantial questions of law arising, my lords. And I request my lords to kindly add. There's 4 substantial questions of law, my lords, which is based at page number 8 and 9.
The appeal has already been admitted. Similar questions.
Please, my lords. Issue pertaining to transfer pricing, my lord.
Dilip Kumar Lane. Have you heard on the question of admission? 4 questions.
My lords, 15, my lords, we've raised 6 substantial questions of law, my lords. All these, my lords, 13 to 17, it all pertains to transfer pricing issues only, my lords. We've raised 6 questions in this appeal, my lords. Page number 9, 10, and 7, my lords. All 6 requires to be admitted, my lords.
How many questions you are proposing?
6, my lords. Lord, 1, 2.
Huh?
1, 2, 4, and 6, my lords.
1, 2, 4, and 6. Right?
Please.
1, 2, 4, and 6.
The petitioner, original petitioner, so the amendment type.
Number 16. A.V. Arvind.
My lords, in this, we've raised 2 substantial questions of law at page number 8 and 9, my lords. Lord, this is, we've raised 4 substantial questions of law, my lord. It is pertaining to the common order, my lord, that's serial number 14, my lord. Serial number 14 and serial number 16, it's a common order, my lord, challenging 2 separate assessment years. 4 substantial questions of law we've raised, my lord.
Then on following subject.
Number 18, Sri Umi Sundarala, Srimati Leela Rani HP.
My lords, I'm appearing for the petitioner in this matter. My lords, I seek 2 weeks' time since the parties are still settling the matter, my lords. We will report the settlement after 2 weeks. The last few days, the parties have not been able to settle. The settlement talks have slowed down because of this whole COVID.
Last date also, 30th November, also you sought adjournment on this ground.
Yes, my lords, I understand.
30th November.
Yes. Yes, my lords. However, the parties are saying that they have been settling the matter.
No, they haven't settled means then argue.
My lords, we can argue on the next date if it's not settled. We suggested the same to the party today.
Please be clear that next date you be ready. Don't have any.
Please, my lords.
Since November, we are in January. January is about to be over.
I understand, my lords.
Master President, Senate Council for the petitioner once again pay for adjournment in order to enable her to report settlement. On 8/11/2021 as well as on 30th/11/2021. Adjournment was sought on similar grounds. However, by way of indulgence, 2 weeks further time is granted to enable the settlement, in which the matter shall be heard.
Much obliged, my lords.
Serial number 19, my lords, may appear for petitioner.
I appear for respondent number 2, my lord. Lord, respondent number 1, bank council is infected by COVID. So you requested me to seek 2 weeks time, my lord.
Yes, my lords.
It's stated at the bar that the counsel for respondent number 1 is unwell in view of offensive submission list after 2 weeks.
Much obliged, my lord.
Obliged.
21, Sri Vasu Kevich, party partner.
Yes. much time? Oh.
I appear for respondent, please.
Yes. Mr. Patil is praying for time.
Yes, sir. No.
Because pay for adjournment this after 2 weeks.
Great.
Number 24, Srimati Tanmay Rajkumar.
Sir, I appear for the appellant. Senior Advocate Mr. Padiwala has engaged in this matter. Could it be taken up on 22nd February? The reason is this, my lords, this matter requires physical consideration.
Wait for adjournment on the ground that the matter has to be argued by the party. Therefore, in outstation council, is there to pay for adjournment. This on 22nd.
Much obliged.
22.
Number 25, Sri K.V. Arvind, Sri Narendra Kumar Jain.
Serial number 25, this matter pertains to transfer pricing. I request my lords to kindly defer it by 3 weeks, after disposal of the Honorable Supreme Court. This matter we can, because there's other batch.
Praise for adjournment on the ground that the issue involved in this appeal is pending adjudication before the Supreme Court. In view of appropriate permission, just after 3 weeks.
Number 26, Sri K.V. Arvind, Sri Arvind V. Chavan.
26, it can be taken up next week,
For adjournment this week.
Number 28, C.I. Sanmati, Sri V. Chandrasekhar.
Appear for appellant, my lord. Ready, my lord.
Ready?
Yes, my lord.
My lord, Chandrasekhar for the respondent, we need to hand over the case law compilation both to the other side as well as file it to the court. I will do it in the course of the day. Matter may be taken up day after tomorrow, my lords.
27th then.
Yes, my lord.
Okay.
27th January.
Yes, much obliged. Much obliged, my lords.
C.I. Karnataka Unit Council for the Revenue with V. Chandrasekhar, Unit Council for Respondent, place for short accommodation. In order to enable him to file a case law compilation. List on 27 January 2022.
Much obliged.
Much obliged.
Number 30, Srimati Tanmay Rajkumar, Sri K.V. Arvind.
Yes, madam.
I appear for the appellant, my lords.
Yes, madam.
This also pertains to transfer pricing, it has to be deferred. This serial number 30 also pertains to transfer pricing issues.
Yes, madam.
The issues do pertain to transfer pricing. Only thing, my lords, the issues are not identical to the batch that is there before the Honorable Supreme Court. I have no objection to the matter being adjourned, my lords, but let it not be recorded as being deferred to await the outcome of the Honorable Supreme Court's order.
Now, Mr. You should examine Mr. Dilip. They have been saying this for quite a while. We remember that each and every case you say transfer pricing, what they say is, we should tell us what is the issue pending before Supreme Court and what is the issue involved in this appeal. At least tell us that, right?
Next week.
Council, not for presence, Unit Council for the Revenue, place for adjournment. This after 1 week. 1 week.
For matters number 6, Sri K. Chandrasekhar, Sri Madhukar.
Yes,
Petitioner is the daughter of the detainee who has been detained under Coffee-Posa by an order passed by the respondent number 2. On the earlier occasion, your lordship would recollect a similar matter relating to the son had come up before your lordship, and your lordship had disposed of the matter. The contention, your lordship, the order of detention on the basis of
in SLP. Mr. Javli, what happened in SLP?
That is pending, your lordship. The issues that I am raising in this petition were not the grounds on which the earlier petition had been disposed of by your lordship.
1 minute, 1 minute. Yes, please.
Your lordship, the order of detention under which he has been detained is found at page number 27, annexure E. In support of the order, as required at law, the grounds of detention have been furnished, which commences at annexure F of page 29. Page 29, annexure F. And to derive the subjective satisfaction to pass an order of detention, the detaining authority has provided to the detainee the list of documents on which reliance was placed, which is at annexure G, page 40. "614 pages of records are purported to have been considered by the empowered officer to derive subjective satisfaction to record the grounds of detention in support of the order of detention." Now, your lordship, what I am trying to submit here before your lordship is that if he derived a particular satisfaction based on records placed before him, then those in accordance with the law laid down would constitute being relied upon documents and are required to be furnished to the detainee pari passu the grounds of detention. Being a document on the basis of which he derived satisfaction to make a particular recording, would be required to be furnished to the detainee along with the grounds of detention. Your lordship, now I have raised, your lordship may kindly see page 31, paragraph 15. Bottom of the page. Page 31, your lordship finds it. On perusal of various documents recovered from the file completed by Gurmeet Singh Kohli, wide your letter dated 6/2020. It is observed that Gurmeet Singh has been a party to the following cases booked by different statutory authorities from time to time. A case has been booked by the Additional Commissioner of Customs Air Cargo Complex, Export New Customs House, Gurmeet Singh, for using or causing to be used for documents and DEPB license obtained on fraud and forgery. In respect of the said investigation, Gurmeet Singh went in appeal against the order passed by the adjudicating authority, which was rejected by the commission. Now, this particular averment has been made by the detaining authority in the grounds of detention. My contention is, where are the documents derive this satisfaction? Get out in the list of documents, page number 40 in Annexure G. The contention in this regard has been raised